IA in criminal appeal. The appeal was listed, but the IA was not listed. Can it be taken up on Thursday, ma'am?
Okay.
Worship, please. May I just mention an anticipatory bail application to be listed today? These are the matters that were listed yesterday. They are again listed 51, 52. One of the accused couldn't file it because she was suffering from COVID. We filed it yesterday. I'm only requesting if the anticipatory could be taken together with 51 and 52 today. I'm extremely grateful.
May I please note it? I'd like to mention for a criminal petition, my lord, on Thursday or Friday.
Yes.
The Lordship mentioned and listed bill application is numbered for tomorrow. Already filed.
Tomorrow. কিমান আছে?
It was already numbered. It is already numbered.
Okay.
Next, I am praying for listing of a case for admission on Friday also. Some
Friday?
urgency is there. Highly obliged.
I beg to mention item number 27 on behalf of A. Kanikar. He has some personal difficulty today, my lord. Kindly, the time is taken
If
up.
they are not received, lordship.
27.
Yes, sir.
On the pair being made by Mr.
M. Soikia.
M.
M. Soikia. I am not on record.
M. Soikia, learned counsel appearing on behalf of Mr.
A. Kanikar.
A. Konikar, learned counsel for the applicant. List the matter on after vacation. On that day, learned additional PP shall produce the case there before.
On 25.
Is there any interim?
Yes. David.
Till then, interim order pass earlier shall continue.
25-1.
A pleasure.
अच्छा देखा এতিয়া সেইদিনা কৈছিলো হেৰিটো কি কৰিলা আৰু জাজমেন্টটো পৰহি দিনা কোৱাটো নাগালেণ্ডৰ Yes.
My lord, I beg to mention this matter for listing tomorrow, my lord. Two bail application, my lord. It's very urgent. Two, my lord. Very urgent, my lord. My lord.
how it is urgent?
Urgent, my lord, due to the stealing, committing theft of a battery of an vehicle, my lord, and where I was earlier arrested. Now, in person to the NBWA, I have been arrested. Now, in 4 months have been elapsed, my lord. Till then, I have been in custody, my lord.
So how it is urgent? He is behind the bar for more than 4 months.
4 months, my lord.
How?
How, my lord, on 11 and 12, my lord, I cannot appear before this court, my lord, due to my medical emergency, my lord. So kindly schedule tomorrow, my lord.
Okay.
God bless you.
May I please, lordship, consider victim mention a criminal appeal matter, lordship, kindly listed this matter for Friday, lordship.
Friday not possible.
Any day, lordship, before.
After vacation. After Bihu. You may choose either 18 or 19.
18.
18.
May I please, your lordship, I beg to mention item number 48, your lordship, supplementary list.
Yes.
Lordship, my prayer for pass over the matter for the day, your lordship, due to my some personal difficulty on any date, your lordship.
Mr. A.R. Karim, learned counsel for the accused.
Scan
Price
copy
for
received, lordship. Scan copy received, lordship.
price for listing the matter when?
May kindly on 18, your lordship.
18. Okay.
Lordship, I have another prayer for listing motion, your lordship, regular bail application, your lordship.
When?
Day after tomorrow, your lordship. Motion.
Day
your
after
lordship,
tomorrow.
439, your lordship.
Okay.
Oblige, your lordship.
May I present? I beg to mention for listing on AB lordship on tomorrow lordship. It was filed on 5th January lordship.
Tomorrow not possible.
Day after tomorrow lordship.
Well, please, lordship, pair for listing, lordship, 3I, all are similar matter, lordship. Lordship, there is
I for what purpose?
for order, lordship.
Okay, after vacation, Bihu vacation.
Lordship, kindly before vacation, lordship, because lordship, they have filed a condemnation of delay, and already we have filed a opposition, lordship, okay, affidavit in opposition. So, lordship,
Okay, 18 or 19, you can choose either of the.
18, lordship.
Huh?
Please.
Hey, please. My lord, I am praying for mention of a case, my lord. My lord, this matter was listed, my lord, custody, my lord. Unfortunately, my lord, it was left over, my lord. So, my lord, this is, my lord, the condemnation petition, my lord, I, my lord. So, my lord, kindly consider, my lord, day after tomorrow, my lord, 11, my lord.
Yesterday not listed.
We started listed, my lord. 8 January, my lord. It was listed, my lord. But it
Listed
was left
before,
over.
I think it is
You got it.
24.
24, my lord. 24.
Yesterday we have not left over any matter.
No, no,
No, my
no,
lord,
it
in
is
court
from
number
court
24,
number
my lord.
24.
Acha, acha.
My lord. But after
14. You go and mention it before court number 14.
my lord, yesterday, my lord, I mentioned, but
14 of
we have-
pension group is আপনার senior bench থেকে। Court number 14. That is,
14.
Please go
Other
through the
24
notice
matter
today.
left.
Please go through the notice today.
how late?
Yes.
Back to mention one DA matter, your lordship, the 21 CA lordship, the petitioner is behind the box since last 1 year, your lordship. And on the last occasion, the matter was listed, but it was left over, your lordship.
18.
Your lordship, on Friday,
No, Friday not possible.
another criminal petition is also there, your lordship. Already compromise is made it out, but there is no entry, your lordship.
Okay, 18 or 19.
I don't mind.
Where is Lordship? Lordship, I beg to mention item number 35, Lordship. Lordship, this is second anticipated bail application. Lordship. Earlier, it was rejected by the Honorable Justice Eddie Sori, Lordship. Lordship, kindly matter may be transferred to the proper bench, Lordship.
Appropriate bench, lordship.
Item number?
35, Lordship.
List before appropriate bench.
I think I covered 14 minor. The LCR has come minor. So that is taken at 2 o'clock, we'll go through the LCR minor,
2 o'clock.
2 o'clock.
Okay.
Obviously.
May I please, your lordship? Lordship, I beg for listing a bail matter, lordship, for withdrawal, lordship, tomorrow.
12.
For withdrawal.
Withdrawal, lordship.
Lordship, may I please your lordship, I beg to mention now for listing a criminal evidence 476 of 23. Lordship,
Oh, 18 or 19.
18 lordship. May I please your lordship, lordship, I'm praying for listing of this criminal revision petition, lordship.
When?
Immediately after view revision,
22nd.
22nd of next.
May I please, your lordship? Lordship, I pray on behalf of Mr. S.K. Jain in respect of item number 36. The first item for orders. He has some personal difficulty today, lordship. Let the matter come up in the first week of February, any date, lordship. Item 36.
Mr. Ganguly, learned counsel appearing on behalf of Mr. S.K. Jain, learned counsel for the applicant, list the matter in the first week of February.
Item number 33, lordship.
30?
33.
33.
My lord, kindly this matter may be taken up day after tomorrow, lordship.
Why?
Lord, I have some problem, lordship.
Madam, case diary is available.
Receive, lordship.
My lord,
Is
this
there-
is not relating to city, lordship. LCR was some scan copy was called for, that is receipt, lordship.
LCR
With LCR.
That is shown in the cause.
on the pair being made by Mr. M. Khan, learned counsel for the applicant, list the matter day after tomorrow.
May I please, Lordship? I beg to mention item number 29, Lordship. Maybe adjourned for today, Lordship.
Why?
Is there receive, lordship?
Some personal difficulty, Lordship.
What personal difficulty?
My senior.
Case diary is available here. Why should we keep the case diary pending here? We will call the matter. No adjournment.
Pray for listing of one anticipated bail application on 12, Lordship.
12 not possible.
Immediately after.
Yes, 18.
Items from daily list, motion bail application, item number 1.
For 39 application, Lordship, the accused petitioner was arrested on 28/11/23, Lordship. Today is 42 days, Lordship.
40?
42 days.
Cyber Lordship, Cyber PS case Lordship, CD may be called for.
Other co-accused has already been declared on bail.
By
This is the honorable court.
after perusing case diary,
Yes, sir.
madam, you when
After.
when bail was granted?
It is the copy.
Madam, you confirm it from your office if the case diary is available, because it was allowed on 22.
Lordship, there are some cases in code number 21 also, which was fixed for case diary, Lordship. So may the matter be taken tomorrow, Lordship, because that. code
Not
will-
tomorrow, if
Same size, CD, Lordship.
you confirm from your office if the
that-
case diary is available, we'll take it up at 2 p.m.
That is on that. Another code.
Oblige.
Number two,
Yes, Your Lordship, put that in an application, my lord. It is a charge sheet case, my lord. Only for the LCR, my lord.
From which court?
My lord, additional session just number 2, Kamrup Metro.
Kamrup. Okay, Registry shall call for the scanned copy of the record along with the case diary from the Court of Learned Additional Sessions as number 2, Kamrup M. Guwahati. Fixing the matter on when?
22nd.
22nd. Sorted, Kamrup.
My lord,
22nd.
oblige.
Item 3,
With your lordship. Lordship, this is seated case lordship, 439 application as on today for 141 days in custody lordship.
Where the case is pending?
Petition session judge number 2, Nagaon lordship.
So commercial quantity is involved.
Lordship.
What is this the case is pending now?
Initial stage lordship.
Charge has been framed.
SARS claim lordship, SARS under section 20 B 2 Roman 2 C and 29 of the NGPS Act. Case 26 lordship.
Registry shall call for the scanned copy of the record of where is the number? Session case number.
Sessions case number. I'm giving.
Hmm? Special NDPS case number 250 of 2023, arising out of Nagaon PS case number 728 of 2023 under section 20B, Roman 2, between brackets, capital C of NDPS Act be called for. Fixing the matter on
19,
Nagaon.
No.
19, 1.
Nagaon.
No,
is from Nagaon.
22.
22. See, along with C.
Item 4,
It will also, the charge sheet matter lordship, for something applicable, it may be called for.
In which court it is pending?
Karimganj lordship, Karim special judge.
Registry shall call for the scanned copy of the record along with the case diary of special NDPS case number 30 of 2023, arising out of Bazir Serda PS case number 81 of 2023 under section 22C 25/29 NDPS Act. from the Court of Learned Special Judge Karimganj. Fixing the matter on
25.
25.
Item 5.
Okay, again pronounce it.
Item 5.
None appears for the accused on call. List the matter when
After 2. After 1.
after one.
After Bihu holiday.
After item 5.
Item 5.
Item 4.
4 to 2 हो Lord.
After Bihu holiday. Item 6.
Based on lordship. 439 of the agreement and the FIR is base 50.
Refer is that page number?
FIR is base number 15.
Twenty-one B Lordship NDPS.
Hmm. At what stage it is pending?
My name is Imtiaz Ali.
Lordship investigation not completed. Lordship.
Not completed.
Not
When he was arrested?
I was arrested on your lordship.
26/12.
26th of 12.
26/12.
Yes.
Well, let the CD come. CD on madam, who is that?
Maybe on 22/1 Lordship.
Sorted. Course of PS
19 Lordship.
19.
Okay. 19 is not possible, lordship.
When?
I have another case outside.
Yes, when?
22.
22. Okay.
22 is Sunday, no? January. 23 may be fixed.
Okay.
23 is Monday.
Item 7.
No, no. 22 is a Monday.
Hey,
এখানে এখানে
বেলেগ চাই তো।
এখানে
23 ধৰিব।
23 বা oh yes sorry here
Lordship Monday.
oh no 22 তারিখ দিতে হবে
ঠিক আছে Monday হৈ যা।
মার্চ
22.
Okay.
may
22. Item 7.
I please your lordship
Yes.
438 application my lord FIR page number 14 my lord. And this section is my lord 120B, 121A, 122, 387, 511. Related section 10, 13, unlawful act, my lord.
Certificate please.
Everything.
Possible.
But allegation is some person demanded money from reputed person, my lord. They have intentionally took my name. Somewhere in Dale, my lord. I have enclosed in page number 24 and 28, my lord.
Twenty-eight Lordship, he was behind the bar for 90 days Lordship.
No, madam, this is a AB.
AB হয় যিটো আপুনি বেলখনৰ অৰ্ডাৰটো দিছে তাৰে কথাটো কৈছে। The one she is mentioning Lordship, he was behind the bar. So this is AB Lordship. Case diary may be called for Lordship. That was BA Lordship.
No, FIR is at page number
14, my lord.
14.
14.
I'm saying about
No,
28
what
Lordship.
is this page number 20?
22 is the seizure list, my lord. 20 is the FIR. Main FIR.
This is vernacular.
Translated copy is the page number 40. Nothing recovered from me, my lord. From home recovered, already he is arrested. And on bail also.
Well, let the CD come. CD on, madam,
Citizen Lordship, 22 Lordship.
22.
Obliged.
Number 8.
May I please, your lordship. Lordship, 438 application, lordship, FIR lordship is at page number 12, lordship. 12. May I read the FIR, lordship?
Yes.
The humble submission of the informant is that I am a resident of the aforementioned locality. With heavy heart, I inform your good self that yesterday at around 9:30 p.m. while I was going to my house from Sohit Bedi, then four unknown youth wearing helmet and mask prevented me near Ma Kali situated near Ramdhenu Dhaba, and thereafter they snatched the key of my motorcycle and by showing pistol they forcefully took me to the nearest cremation ground. After taking me there, they said that what we will say, you have to abide by that. Else, by this pistol, you would be kicked and keep here. They demanded that you have to give us 30 lakhs rupees by 15/3/2022. Otherwise, we will occupy your all landed properties and you would not be able to reside here in Domisapara along with your family. They have forcefully taken my signature on 5 stamp papers. Lordship, thereafter, lordship, in this case, lordship, police has submitted final report. Lordship, may kindly come to page number 18.
Final report.
Final.
Page number 18.
18. 1. Second paragraph, fact disclosed during investigation.
Yes.
During investigation, the place of occurrence was visited and this case was drawn. After interrogation, statement of the informant was recorded. As the place of incident is a deserted place and there is no residence in the nearby areas, therefore no witness was found and the informant was stated that he doesn't know the accused persons. The employees of the Ramdhenu Dhaba, which is situated near the place of incident, were interrogated, but they stated that they saw nothing and heard nothing on that day. The employee of the dhaba stated that during the evening hours, some youths generally comes by their respective motorcycle to that place and drinks wine. And the boys are not of this locality and we do not know them. On the other hand, when we interrogated the shopkeeper of Jailkasar and asked him about the incident of 8/3/2022, then he stated that he has not heard anything and he does not know the boys involved in the said incident. Therefore, without keeping the case pending and after due discussion with the officer in charge of the police station, the present final report is being submitted before the honorable court. As no information could be gathered about the accused person, though the incident is true under section so and so. Copy of the case map is annexed along with the final report. Now, Lordship, after receiving this final report, Lordship may kindly come to page number 25. This was the order passed by the learned CCM, Lordship. CR put up today in the petition number so and so filed by the complainant Apurva Singha by stating therein that he has objection to accepting the FR in this case by showing cause of the said petition. I have perused the case record and also the FR submitted by the IO. I am not satisfied with the grounds of submitting the FR in this case. Hence, FR is rejected. The case is again sent back to the OC Bongaigaon PS for reinvestigation in this case by appointing another IO. Lordship may kindly come to page number 27.
Pardon?
Lordship may kindly come to page number 27.
No, if the final report has already been submitted, is there any apprehension of arrest?
That has been rejected, Lordship. The final report has been rejected. Direction was given.
No, that's all right. It means that there is no case against you.
But Lordship now, Lordship may kindly come to page number 27 for it.
Hmm.
The complainant herein, Lordship, is my own maternal uncle. And Lordship, on the day of incident, Lordship, there was an altercation, Lordship.
No,
between-
this is a compromised data.
Compromised it, Lordship.
Yes.
Compromised it between the informant and the present petitioner. Lordship.
Uh,
As because, Lordship, the police is now searching my house, Lordship. They are looking after me, Lordship. Once they got the order of the honorable court by which Lordship FR has been rejected.
so the complainant has entered into a compromise.
Yes.
Did along with the
Present petition.
heard Mr.
M. Ahmed.
M. Ahmed, learned counsel for the applicant, and also heard Madam Begum, learned additional VP for the state respondent. Apprehending arrest in connection with Bongaigaon PS case number for Bongaigaon PS case number 138 of 2022 under section 341, 365, 418, 506, 34 IPC. This application under section 439 service or 438 services preferred by applicant Dipankar Roy for grant of arrears pay. The above noted case has been registered on the basis of one FIR lost by one Apurva Narayan Sinha on 9/3/2022. The essence of allegation made in the FIR dated so and so is that on the night of 8/3/2022 at about 9:30 p.m. while he was proceeding to his house from Sohid Bedi, then four unknown person wearing helmet and mask prevented him stopped him near Ma Doxina Kali Mandir, situated near Ramdhanu Dhaba, and thereafter they snatched away the key of his motorcycle, and on gunpoint they have taken him to nearest cremation ground, and thereafter they have demanded a sum of rupees 30 lakhs within 15/3/2022. Alice threatened to grab his landed property. And also threatened him that he will not be able to reside in Dosimpara along with his family members, and also forcefully taken his signature on stamp papers. The learned counsel for the accused submits that the applicant submits that upon the FIR lodged by the informant, the officer inserts Bongaigaon PS has registered Bongaigaon PS case number 138 of 2022, and after completion of investigation, the investigating officer returned the case in final report being FR number. What is the FR number?
230 of 2022. Case number 20,
230.
Lordship.
230 of 2023.
22.
22.
Dated 6/6/2022.
Dated 6/6/2022. 2022. But learned Chief Judicial Magistrate by order dated 4/12/2023 has not accepted the FR and directed the officer in search to get the case investigated again by engaging another IO. The learned counsel for the petitioner applicant further submits that the applicant is the own maternal uncle
Informant is the own maternal.
that maternal uncle of
of the petition.
that the informant of the case is the own maternal uncle of the applicant, and that they have entered into a compromise deed on 9/12/2023,
Yes, sir.
and that the applicant is being searched by police, and therefore he has apprehension of arrest, and therefore he approached this court by filing the present application. And therefore it is contended to allow this petition. On the other hand, the learned additional PP submits that case there may be called for. Having heard the submission of learned advocates of both sides, perusal of the case there is found to be necessary, and accordingly it is provided that the case there be called for, fixing the matter on
6-2, Lordship.
6/2. Having considered the nature and gravity of the offense, and also the submission of learned advocates of both the parties, this court is inclined to extend interim protection to the applicant till receipt of the case there. And accordingly, it is provided that in the event of arrest of the applicant in connection with Bongaigaon PS case number so and so under section so and so, he shall be released on interim period as bail on his executing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Last condition is shall not leave the jurisdiction of CGM Bongaigaon without prior permission.
Highly obliged.
Item 9.
Okay, in the interview, may I interrupt, Lordship? I wrongly went to another item number 5, Lordship.
Item number?
5, Lordship. B and 439 application was there.
Okay, we'll take it up at 2 p.m.
Lordship, highly obliged.
Item 9.
Yes, please. 438 application against gross FIR. Page 7,
Page
7, gross FIR. Litigation against the petitioner, they have assaulted the informant. That is it. Okay. Another FIR lodged by the petitioner wife, page 12,
which is the other FIR?
page 12, annexure 2.
Yeah, heard Mr.
LVU.
Learned counsel for the applicant, and also heard Madam Begum, learned additional PP for the state respondent. This application under section 439 services prepared by 438 services prepared by applicant Krishna Pradhan, who has been apprehending arrest under section apprehending arrest in connection with Gopur PS case number 247 of 2023 under section 447 T24 third IPC for grant of various faith. Be it noted here that above noted case has been registered on the basis of an FIR lodged by one Jotin Bora on 12/12/2023. The essence of allegation made in the FIR dated so and so is that on 11/12/2023 at about 6:45 p.m. Accused Krishna Pradhan came to his house and attacked him by means of sharp object and caused injuries to him. Mr. Gogoi, learned counsel for the applicant, submits that the FIR dated 12/12/2023 lodged by Sri Jotin Bora is the counterblast of the FIR lodged by Srimati Rupa Pradhan. Who is Rupa Pradhan?
Wife of the petitioner.
Wife of the present applicant on 12/12/2023. and that the applicant is innocent and no way involved with the offense alleged in the FIR, and therefore and he is also ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. Whereas the learned additional PP submits that case jury may be called for at this stage. Para, having heard the submission of learned advocates of both sides, perusal of the case jury is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case jury along with the injury report of the victim on
6-2, Lordship.
6/2. 6/2.
Interim.
Para, having considered the submission of learned advocates of both the parties and also considering the nature of accusation and the punishment prescribed for the same, this court is inclined to extend interim protection to the applicant till receipt of the case diary. And accordingly, it is provided that in the event of arrest of the applicant in connection with Gopur PS case number so and so under section so and so, he shall be released on interim period bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. That shall not leave the jurisdiction of subdivisional judicial magistrate and Gopur without prior permission.
Item 10. Also, for 38 application, Lordship, page 14 is the FIR, Lordship. What? May I read, Lordship?
Yes.
Most respectfully begs to state that in the year of 2020-21, while my daughter, namely Sabina Yasmin, studying in the Kolgasias Junior Alcohol College, falls in love with the accused number 1. By taking chances of that love relationship, the accused number 1 captured some obscene photos and videos of Sabina Yasmin in his mobile. 123/423 socially solemnized the marriage of my said daughter with the accused number 2 by following Islamic rites. But it is a matter of regret that aforesaid two accused person with conspiracy since few days did viral the obscene photos and videos of my daughter in social media and hurt her positively. My daughter, being informed about the said incident, loses her mental condition and tried to commit suicide. These persons are with pre-planned harm the modesty of my said daughter, Lordship. After this FIR, Lordship, in this FIR specific allegation against the accused number 1 and the accused number 2, Lordship. This case was registered initially under section 120B 354C IPC radio section 66E ITI, all are bailable section. Accordingly, Lordship,
No, whether 354C IPC is bailable offense.
yes, Lordship, punishment is maximum 3 years, Lordship. Not less than 1 year, maximum is 3 years, Lordship. But Lordship, in this case, Lordship, both the accused persons are surrendered before the trial court. And honorable trial court, learned trial court, Lordship, allowed the bail to the petitioners, Lordship. Subsequently, Lordship, the IO of this case, Lordship, make a prayer before the learned court below to attend section 4 of the POCSO Act, Lordship. Accordingly, Lordship, prayer was allowed and section 4 of the POCSO Act added in this case, Lordship. After that, Lordship, Lordship, IO make a further prayer before the learned court below to allow to arrest them, Lordship. Said order I have annexed, Lordship. Lordship, annexure 6, page 26 and 27, Lordship. And thereafter, Lordship, IO Lordship started searching to arrest them, and accused number 1 is arrested, Lordship, and forwarded him to the jail hazard, Lordship. And Lordship, accused number 1 move a bail application before the learned court below, Lordship.
So, you say POCSO sections are there.
Yes, Lord.
So at this instance, notice will go to the respondent number 2.
Yes, Lordship, that is Lordship required. Notice has to be issued to the.
And we'll also call for the case date.
Lordship, in this case, Lordship, my part is, Lordship, I am the husband of the victim girl. I have solemnized marriage with the victim girl. My marriage
So
certificate
a
was
specific
also
allegation against you there that there is conspiracy between accused number 1 and accused number 2.
This is, Lordship, in the paragraph.
So
11,
we'll
Lordship,
peruse the case date.
Lordship, in the paragraph 11, Lordship, I
Okay,
have listed
let
it,
notice be issued to the respondent number 2,
Lordship. What is it
returnable
required,
on
Lordship? Yes.
On 19, Lordship, 19 1.
19 by registered post and also by usual process and also through the officer insert jurisdictional PS. The learned additional PP shall produce the case diary along with the statement of the victim guard recorded under section 164 CRPC and also the medical document on 19th.
Thank you, Lordship. Lordship,
Item number 11.
Hello there. Say, better, my lord, Krishna is the manager of Kalansa Tea Estate. For default of provision fund used, my lord, this garden was attached. Thereafter, my lord, the consent of the provision fund organization, it was leased out to one Assam trading company. Annexure 3 is the lease deed, as per which, my lord, they have to deposit 1 crore in 16 installments. But they failed to deposit the same. So, my lord, one case was filed earlier also. My lord, up to 22. That there is at page 36. Same, my lord, that was up to 22, and your losses has granted the bail. Your losses bail order is at page 38, my lord. Now, my lord, they have added one year more, same, my lord, actually, and file another case, my lord. In fact, my lord, there is provision under Assam Tea Plantation Provision Fund Act, my lord, section 7 is there. Without filing any case under that provision, my lord, they have filed under IPC. There are various modes.
Where is the FIR?
FIR is at page, my lord, 10, present FIR. Earlier FIR is, my lord, at page 37.
No, 11 is the FIR.
11 is that. Here is
The applicant is the
manager of the tea estate.
manager of the tea estate. And he failed to deposit the
Yes. My lord, that is 26. Provision fund from 26/9/20 to 23/8/23.
what was the amount? 28
About
lakhs.
28 lakhs. Earlier, my lord, your loss will find in the earlier Azahar, they have shown 25/4/22, 28/4/22. Actually, my lord, overlapping. Same. And PN Trading Company, my lord, that is the main person, my lord, who is in the lead, my lord, who has to deposit the amount. That is why, my lord, your losses, my lord, granted bail earlier. That lead your loss will see that lead starts earlier, page 20.
Mm.
There is a provision, my lord, in the lead itself is there that they have to deposit 1 crore. At page 21.
So in the Plantation Labor Act, there is provision
Yes, my lord, your loss.
for recovering.
Section 7 is there.
What 7 says? What
Yes.
that section says?
That section says, my lord, the punishment provided, penalty is there, my lord. It is up to 6 months, which may extend to 1 year, 1,000 rupees fine also. They have power to recovery also, my lord. They can issue recovery certificate, they can attach the garden, they can sell the garden. Everything is there.
Mm. Yes, madam.
Lordship, he defaulted in paying the amount, Lordship. Earlier also, that only that issue, Lordship. CD may be called for, Lordship.
So for recovering the said amount, there is special provision in
Provision is there,
the
Lordship.
Assam Tea Plantation.
In Amendment Act also, my lord, there are various provisions for
Mm.
recovery.
So why they have filed this criminal petition? Oh, no, sorry, criminal case against. No, this
IPC section,
case is under IPC.
Just to arrest, my lord, but without going to the provisions, my lord, they wanted to.
Heard, Mr. Chaywala, learned senior counsel assisted by Mr. So-and-so, learned counsel for the applicant and also heard Ms. A. Begum, learned additional PP for the state respondent. Apprehending arrest in connection with Colline PS case number 532 of 2023 under section 420 406 IPC. This application under section 438 services prepared by accused Sam George for grant of previous pay. The above noted case has been registered on the basis of an FIR lodged by Assistant Fund Control Officer of ATEPF Organization, Karimganj Inspectorate Office on 13/10/2023. The essence of allegation made in the FIR dated so and so is that the applicant, being the manager of Kaline Sierra Tea Estate, which in bracket C-54, has failed to deposit provident fund contribution deducted from the wages of the worker amounting rupees 28,71,252.85 rupees for the period 26/9/2020 to 23/8/2023. And the subsequent period also, the accounts have not yet been submitted by the employers to his office. Mr. Sahil, a learned senior counsel for the applicant, submits that earlier also the informant has lodged one case against the present applicant.
Yes, sir.
Upon which
Align PS case number 134/22.
where is the order?
Well, order is at page 38.
38. Being Kaline PS case number 134 of 2022 under section 188 406 408 420 IPC, and the applicant has preferred an application for grant of periodic bail being AB number 1933 of 2022, and this court was pleased to grant the privilege of periodic bail to him by order dated 31/8/2022, and that again the informant has lost the present case against the applicant, and that there is provision in the Assam Tea Plantation PPE scheme at Act 1955 for recovering the PF contribution, but without resorting to the said provision, the informant has lost the case under the provision of the IPC against the applicant, and that the applicant is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Ms. Begum, learned additional PP, submits that at this case there may be called for. Having heard the submission of learned advocates of both sides, perusal of the case theory is found to be necessary, and accordingly it is provided that case theory be called for, fixing the matter on
7-2, Lordship.
7-2. Considering the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to extend the privilege of interim periodic bail to the applicant till receipt of the case ID. And accordingly, it is provided that in the event of arrest of the applicant in connection with Kaline PS case number so and so under section so and so, he shall be released on interim periodic bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CJM CASA without prior permission.
My lord, item 47 is there, my lord. In the same case, my lord, this time, my lord, the director who is residing in Kolkata, he has been also a trial party. Same case.
Same PS case.
Yes, same case. Same. same affair. This time who is residing in Kolkata, he has also.
Where is the FIR here?
My lord, yes, FIR is at page, my lord, 11. Your lordship will see the third paragraph.
Hmm.
Ajay Pugalia, Director, Logo Tea Company, British India Estate, 4th floor, room number so and so, Kolkata. He is only one of the directors. There are 3 directors are there. Along with the manager.
Second to same হলো নামটো খালি বেলেগ হ'ব আৰু এইটো ডাইৰেক্টৰ আগৰটো Okay.
FIR is at page 8, lordship. You can see the allegation against the present national, your lordship will see. May I, lordship, read the FIR, lordship?
POXO 4 is there, lordship.
And then
There
it
must
says
be-
let notice go.
But that is, there to go, lordship. So far, the allegation against the present petitioner is personal, lordship. If your lordship kindly go through this lordship FIR, your lordship will find that there is no.
That's all right, but without serving notice upon respondent number 2, would it be proper to grant any relief to you?
Some hearing protection that way.
No,
You
no.
know, without. Well, some co-request has already approved before this honorable court, and this honorable court has lordship granted bail.
No, that may be the some other courts may grant it, but I don't think that without hearing the other side, it would be proper to grant you any relief.
Short date.
19-1, lordship.
Let notice me issued to the respondent number 2 by registered post and also by usual process and also through the officer in charge jurisdictional PS returnable on
20, lordship.
20.
20 Sunday.
22.
22. Well,
22.
Well.
22. And on that day, learned additional PP shall produce the case diary along with the statement of the victim girl recorded under section 164 CRPC and also the medical report of the victim girl.
Item number 13. Maybe the lordship, division for 38 bail application. In connection with KPS case number 128 slash 2023. Case number 10. In this petition here, 2 petitioners. Petition number 1, the mother, and petition number 2 is his son. Petition number 1 is the driver. Sorry, owner is it in the vehicle. In question vehicle.
One is the
Petition number 1 is the owner, registered owner of the vehicle in question. Already, Your Honor, in this case, subsequently, one is one person is arrested. He is the husband of the petition number 1. And he got,
So we'll see the rule played by her. Let the CD come. Madam, when?
CD 19-1, lordship.
19-1.
protection is hidden here.
No.
Item 46.
Apply.
46.
For it to application, your lordship, your lordship will find the review order at page 29. Your lordship, on receipt of the charge sheet, NWB was straightly issued against the petitioner, lordship. No summon was issued on first day. At first instance itself, lordship. At page 29.
POXO 4 is there, lordship.
The 4 is there. lordship.
376-3.
Service of notice upon the respondent number 2 may not be required because the right of the victim is not affected in any manner.
Page number?
Page number 29, Lordship. The investigating officer has submitted charge sheet against the accused. Further, under section so and so, where is the charge sheet and the materials available on record upon such perusal, cognizance of offences under so and so is taken in the case. Register it as a special POCSO case, issue NBW against the accused name. So on 9/11/23, NBW was issued against me without there being any reflection that I was absconder or something else. But on 10, if you Lordship, there is this page number 30. Now, where I am in dilemma, Lordship, at page number 30, the police came to my house and handed over me a copy of a summon issued by the same court. The order dated 9/11 says NBW was issued and police handed over me a charge sheet which was issued on 10/11 on the very next day under the signature of the solicitor of the same court. So, Lordship, if I appear in terms of this summon, I will be put behind bars because of this order. And this order nowhere says that I was absconder. There was no opinion formed. Absolutely illegal order, Lordship. The matter is fixed tomorrow, Lordship, before the trial court for appearance.
No, but the fact remains that you have been shown as absconder in the search sheet.
Yes, but in the order sheet, there is no reflection. There has to be a satisfaction before the court that I was absconder. Order is absolutely silent. The satisfaction is inside the mind of the trial judge, not in the order. There is no reflection. At least a reason order has to be passed. Why a warrant is required to be issued instead of summons? Even though I was shown as absconder, and in fact, police can't declare me absconder.
Yes, madam?
Lordship, let the notice be go there and in between, Lordship, if he appear, Lordship, then till appearances, let it be keep the NBW in abeyance, Lordship.
But see, tomorrow is the date fixed. If your Lordship is set aside this order, then I will appear. But this order may be treated as
No,
not as
till
an
appearance,
NBW.
it may be kept under abeyance, Lordship, because
Yes.
POCSO 4 is there, Lordship, so set
No,
aside,
you want the matter to be disposed of today or we will keep it pending?
let him appear and we'll keep it pending, Lordship.
Lordship may dispose it off because tomorrow the matter is fixed.
But without hearing the other side?
Other side, it cannot be, Lordship, because POCSO 4 is there.
In that case, Lordship, the order dated 9/11, it shows that this is completely bad in law because nowhere says that I'm absconder.
The search sheet,
Or-
it is,
No, the charge sheet may show that I was absconder. The police may have submitted
Is
charge
that-
sheet showing me as absconder. But what police did in the charge sheet, they declared me as absconder and thereafter they submitted absconder charge sheet. And
The-
court below, without finding any
Lordship,
opinion,
he is not cooperating with the investigation officer, Lordship, so what? He has been declared absconder, Lordship.
I have not been declared absconder. That is my point. Without declaring
Are
me as
Mr.
absconder.
Your good name?
Our Bora,
Yes.
Lordship.
Learned counsel for the petitioner and also our Ms. A. Begum, learned additional PP for the state respondent. In this petition under section 482 CRPC, the petitioner has put to challenge the correctness or otherwise of the order dated 9/11/2023 passed by the learned special judge North Salmora Vayapuri in special within bracket P case number 173 within bracket J of 2023. It is to be noted here that by impugn order dated so and so, the learned court below has taken cognizance of the offense under section 376(3), 341 IPC, reduced section 4 of the POCSO Act, and issued non-bailable warrant of arrest against the petitioner. The learned counsel for the applicant submits that the applicant has been succeeded in the aforementioned case under section 376(3), 341 IPC, read with section 4 of the POCSO Act.
Read with section 75 of JJ Act is also there. Lordship.
No, that is,
And the learned court below on the very first that has issued non-violable warrant of arrest against the petitioner for being shown him as absconder in the search sheet, and that the order impugned is illegal and not tenable in the eye of law, and therefore it is contended to set aside the same. Mr. Bora further submits that though void order dated 9/11/2023, non-bailable warrant of arrest was issued against him, yet on when you have received the summon
Someone Lordship, after 2-3 days, I received the summons. Lordship.
and immediately after 2-3 days of the order dated 9/11/2023, the petitioner has received one summon to appear before the learned court below on 10/1/2023 at
24.
about 2024 at about 10 a.m. And that he has the petitioner has the apprehension that if he appears before the learned court below on that day, then in view of order dated 9/11/2023, he may be put behind the bar, and therefore it is contended to set aside the impugned order dated 9/11/2023. On the other hand, Ms. A. Begum, learned additional PP, has opposed the petition on the ground that the petitioner has absconded and he did not cooperate with the investigating agency, and therefore he has been shown as absconder. And that at this stage, notice may be issued to the respondent number 2, and the impugned order may be kept in abeyance. Pero, having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record carefully, and also perused the impugned order dated 9/11/2023. It appears that while taking cognizance of the offense under section 376(3)(3)41 IPC, related section 4 of the POCSO Act, the learned court below has ordered for issuing non-bailable warrant of arrest against the petitioner, namely Fazur Ali. It is also to be noted here that the petitioner has been shown as absconder in the search sheet dated
39/2023.
dated 30/9/2023. Though the petitioner has been shown as absconder in the search sheet, the learned court below, no, it is well established that the learned court below ought to have issued summon to the petitioner on the very first occasion, as required by Honorable Supreme Court in the case of Indra Mohan Goswami versus State of Uttarakhand. Citation to notice what it is. Having tested the impugned order on the touchstone laid down by Honorable Supreme Court in the case of Indra Mohan Goswami, this court is of the view that the impugned order dated so and so failed to stand the test of legal scrutiny, and therefore this court is inclined to set aside the same. In the result, this petition stands allowed. The impugned order dated stands set aside and quashed. The petitioner is directed to appear before the learned court below and to apply for regular bail, and in the event of filing such an application, the learned court below shall consider the same in accordance with law.
Item number 15, matters for bail hearing.
At our line, given the nature of relief being sought in this petition, this court is not inclined to keep the matter pending.
May I please, your lordship. My lord, office note dated 15/11/2023, my lord. Reveals that the my lord service to the respondent number 2, my lord, is complete, my lord. 15/11/2023. Speed post and AD card already delivered to the my lord address C, this is respondent number 2 at flag number D and E.
Yes, madam. Oh, yes, Borwa.
My lord, the charge that case, lordship, my lord, now
My lord, trial is going on. My lord. Today is my lord 114 days, my lord. He is behind the bar, my lord. Arrested on my lord 26/12/2022.
26.
12/2022.
How many witnesses have been examined
But 5 witnesses examined, my lord.
out of?
Out of 8, including my lord victim and the informant. Informant is the mother of the victim, and the my lord victim herself also examined, my lord.
So,
And my lord, there is some my lord, no communication between one witness to other, my lord.
there is some.
My lord, communicate, no chain, my lord. Some mid chain, my lord. Because my lord, mother, my lord, said that the victim was, my lord, read in class 9, but she did not produce the birth certificate. There is a case of POXO, my lord. So birth certificate or the my lord, the school certificate is necessary to prove that my lord her birth, my lord. So my lord, mother said that she is my lord 17 years at the time of my lord offense. She said that she was 16 years. So my lord, as per the Ranga, my lord, 2 years, my lord, up and down, my lord. Since the beneficial less than
As
my lord,
per
2 years, my lord. My lord,
which is beneficial legislation.
my lord, this is my lord the beneficial reason. So my lord, benefit goes to the my lord.
Which is POXO Act.
My lord, in fact, my lord, POXO, my lord, and other acts are since the my lord welfare state, my lord.
POXO Act is beneficial piece of legislation.
Yes, your lordship.
Where do you got it?
My lord, since my lord Rangaya, my lord said that my lord.
Who is Rangia?
Joymala, sorry, my lord, Joymala case. On either side. Para 9. Middle portion. Two years on either side, my lord. So it may be, my lord, less than
Para 9.
Para 9, my lord.
Do you know the subsequent judgments?
No, my lord.
Para 9.
Para 9, my lord.
Where it is stated?
4, 5, 6, 7, 8, 9th line, my lord. 8 and 9. However, it is notorious and one can take judicial notice that merit of error is in as ascertained by radiological examination is 2 years on either side, my lord.
Do you know that that judgment has been overruled by a subsequent judgment?
No, my lord.
No.
As per my inquiry, my lord,
Mm,
this is my lord still exists, my lord,
Still exists.
my lord. And here, my lord, my mother said that she was reading in 9,
Hmm?
but no, my lord, her S proof produced before the my lord learned trial court.
No?
No, my lord, S proof certificate, either my lord birth certificate or school certificate. Kindly see, my lord, kindly see, my lord, my lord, the state, my lord, deposition of the informant. That is the mother of the my lord Renuka Gwala, mother of the my lord LS victim.
Mm,
Deposition page 2, cross examination by defense. In support of age of my victim daughter, I have not submitted any document.
mm,
And on the first page, my lord,
Mm.
on oath from the bottom,
mm,
fifth line, sixth line, my lord.
mm,
The accused Muhammad Abdullah, who was responsible for causing pregnancy of my victim daughter. So, my lord, regarding my lord, the reading, my lord, my lord, the victim stated that, my lord, page victim statement,
mm,
page 2.
mm,
At the time of occurrence, my age was 16 years and I was reading in class 8.
mm.
So, my lord, she must have, my lord, the S proof certificate, my lord, but they did not produce, my lord. So, my lord, the POXO cannot be attracted in this case, my lord.
Mm.
And my lord, he already spent, my lord, more than 1 year, my lord, behind the bar, my lord. So, at least, my lord, on the basis of length of detention, my lord, he may be released, my lord. He is, my lord, local resident of that area, my lord.
After this judgment, there was a judgment of 3 judgments
My lord.
where it is stated that this 2 years plus minus is without any basis.
Even my lord,
Hmm?
since she stated that she was
That
reading
is the judgment of this state of Karnataka versus Bantara Sudhakara, 2008 11 SCC, page number 38.
8, 11 SCC.
2008 11 SCC, page number 38.
38.
State of Karnataka versus Bantara Sudhakara.
Even she herself stated that she was reading in class 8,
Hmm.
but her S proof certificate, my lord, did not produce before the my lord trial court. So it reveals that my lord, she
Now,
was
whether
my lord,
medical document has been
medical
produced?
exam, radiological examination as per 16, 17 years, my lord.
16.
16, 17 years.
Then what is the definition of this child in the POXO Act?
Less than 18, my lord.
Less than 18.
My lord.
Then
My lord, radiological examination, my lord, is a my lord examination. It's not exactly the same, my lord. It is, my lord, tentatively, my lord, arrived at a conclusion that, my lord, her age, my lord. So it is not exactly, my lord. And in fact, my lord, in the meantime, my lord,
Hmm.
IO, my lord, submitted an application before the, my lord, learned trial court
Hmm.
for, my lord, further investigation regarding that, my lord, the DNA test of the, my lord, soil of the bird. So it's proved that, my lord, there after investigation they have some doubt, my lord.
Some doubt.
My lord,
Hmm.
kindly see them.
But the thing is that the court below has framed charge against you under
Yeah,
the
my
sixth
lord,
section.
6, my lord. So,
Hmm. Then
my lord, kindly see them, my lord. This, my lord, prayer of the IO, my lord.
no, that's all right. They may continue it. Where is the bar?
My lord.
Hmm?
One year, more than 1 year, my lord, is a sufficient time, my lord. at least, my lord, length of detention may be considered, my lord. And he may be, my lord, at least,
No,
given-
case is at the end of the fag end of the trial. Hmm. Out of 8 witnesses, 5 have already been examined.
my lord.
When the case was listed last,
Last listed on, my lord, the 22/12, my lord, before this honorable court, my lord. This bail application. Before trial court, my lord, I need to say, my lord.
hmm,
The last PW was examined on 26/6, Lordship. 26 June.
thereafter no witnesses examined.
The witnesses have not turned up, Lordship.
Hmm.
And in fact, my lord, another witness, who is the, my lord, adjacent shop, my lord, of the petitioner's, my lord. After his admission, my lord, there was no such incident taken place, my lord. My lord, kindly see the, my lord,
At this time, Lordship, the.
Torun Kakoti, my lord,
So the court is not
PW.
I think the my lord evidence, Lordship, because only the prima facie Lordship will see whether there are any evidence or not, my lord, in respect to rape and my lord.
And his behavior has also, my lord, well explained. Kindly see, my lord, PW2, my lord. He's a, my lord.
No, the
shopkeeper
problem
at the-
is that this court is not supposed to appreciate the evidence.
My lord,
That is the business of the trial court.
only my length of detention, my lord, considered. My
Length of detention,
my lord, more than 1 year, my lord. And already, my lord,
only the MO and IOs are there. Oh, examination.
my lord, page 23, the name of the witness mentioned in the charge sheet, my lord.
Let us status report come from the court below. Heard Mr.
M Islam.
M. Islam, learned counsel for the accused, and also heard Mr. RJ Borua, learned additional PP for the state respondent. The order dated 22/12/23 indicates that the latest status report of special POCSO case number 4 of 2023 was called for from the Court of Learned Special Judge Udalguri, but the same has not yet been received. In view of above, it is provided that registry shall call for up-to-date status report fixing the matter 19.
My lord,
19. The learned counsel for the accused, referring to office note dated 15/11/2023, submits that notice upon respondent number 2 has been served. And as such, the matter may be heard. So, on next that, immediately after receiving the report, an endeavor will be made to hear and dispose of this matter finally.
item number 16, highly oblige your lordship.
But, Mr. This POCSO Act is not a beneficial piece of legislation.
I'll say. Highly oblige your lordship.
May I please, lordship, the charge-sheeted case, lordship, NDPS, lordship. Today is, lordship, 473 days behind the bar.
400?
473 days, lordship. No, no witness was examined.
But on the other day, PR was made that time may be granted to produce some judgment of the Supreme Court. Where is those judgments?
Today I have not, lordship. Oh,
On 7/12/2023, adjournment was sought for and granted also on that ground. Where is those judgments?
on Friday, lordship.
Friday.
Friday, too many cases.
Many cases, lordship, after the
Friday, too many cases have already been.
Thursday.
after view holidays.
Review.
18th? That's right for by Mr.
And Ahmed.
Ken Ahmed, learned counsel for the accused, released the matter on 18th. On that day, the learned counsel for the accused shall produce the judgments of Honorable Supreme Court in view of order dated 7/12/2023.
Item number 17,
Please, Lordship. My lord, this is for 39 application, my lord. I am behind the bar since 181 days. As such, my lord, mandatory period is over. My lord, this is a commercial quantity, lordship, and my lord, this investigation is pending only to collect the FSL report, my lord. That is the lordship, my investigation could not be completed, lordship, and I found from the case diary, lordship, the extension of time was not sought, lordship. Extension for further investigation.
So what is the mandatory period? 180 days.
180.
180 days completed.
My lord, completed. Today is 181 days.
Search it not submitted.
I should not submit.
So then Where is the question of producing this FSL report?
Because probably the investigation.
It is a fact that search sheet has not been submitted. So default bail, he will entitled to default bail. Heard, Mr. Learned counsel for the accused and also heard Mr. RJ Borua, learned additional PP for the state respondent. Apprehending arrest in connection with Sangsari PS case number 231 of 2023 under section 22, which in bracket C NDPS Act. This application under section 439 services prepared by accused Mustafa Ali alias Mustafa Ali for grant of bail. The above noted case has been registered on the basis of one FIR lodged by one
Reduction Ramsiari.
on the basis of one FIR lodged by SI Reduction Ramsiari on 13/7/2023. The essence of allegation made in the FIR dated so and so is that on 13/7/2023 at about 6:25 PM, he, along with police party, apprehended one Hyundai Activa scooty bearing registration number AS01FB1320, which was coming from Guwahati side towards Bayatasarel. And on being searched, they have recovered suspected 11 bottles of chlorpheniramine maleate and codeine phosphate syrup. Weighing 1100 ml and 14 striped nitrazepam tablets. Total 140 numbers. And case rupees 14,850 and also one mobile phone. From the stories of the scooty, which was driven by the accused Mustafa Ali. Mr. Parmanik, learned counsel for the accused, submits that the accused was arrested on 13/7/2023, and since then he has been languishing in jail as for last 181 days. 81 days, and that the mandatory period of detention already over, and till date no search sheet has been submitted by the IO here in this case, and on such count the accused is entitled to default bail, and therefore it is contended to allow the petition. On the other hand, Mr. RJ Borua, learned additional PP, has produced the case before this court, but submits that and submits that the FSL report is not available in the case ID, and the case is pending for collection of the aforesaid report. Mr. Borua further submits that till date 181 days over, and there was no pair was made by the IO for extension of the time for investigation. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record. And it appears that the accused was arrested on 13/7/2023, and since then he has been languishing in jail as for last 181 days. Admittedly, no charge sheet has been submitted till date. And also no pair is made for extension of the time of investigation. It appears that the case is pending for collection of the FSL report. Under the aforesaid facts and circumstances, this court is of the view that the accused is entitled to default bail, and accordingly it is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned
Special just Kamrup Amin Company.
Special Judge Kamrup Aminggaon, the accused being enlarged on bail in terms of above this BA sense disposal.
Highly.
Item number 18.
May I please your lordship? This is an application under section 439 of CRPC, your lordship. Petitioner, your lordship, was arrested way back, your lordship, on 14/7/2023, virtually.
Whether notice was served upon respondent
Notice,
number.
your lordship, served.
When?
Your lordship, on last occasion, your lordship. Charges probably is complete, your lordship. Office notice I see. You know. Next lucky logo like that.
At what stage the case is pending
Your
now?
lordship, SARS has been framed, your lordship, evidence has not been taken into your lordship. And 6 months is behind bar, your lordship. And
SARS has been framed,
framed.
but no witnesses turned up.
No. Now, if your lordship comes to the FIR,
Mr. Borthakur,
lordship,
let the evidence of the victim be recorded.
at least 15.
We'll keep the matter pending. When the next date is fixed,
Your
before the court below.
Here, date, your lordship, 15 days, I was told that the exact date they could not provide me, but your lordship, in this month itself, the date is there. In
No,
January itself.
15 days is there, but whether that next date is
It's
fixed
for
for evidence or
evidence,
not.
For evidence, sir.
Okay, we'll fix the matter after holidays.
Lords,
In the meantime, we will call for up-to-date status report.
lords. Only thing, your lordship, the FIR as it has evolved, your lordship, there's no allegation of POXO in the FIR, your lordship. It was a simple FIR, your lordship, where it was alleged that he has taken away mobile phone from this lady, your lordship, victim, your lordship. Now, subsequently, when he, your lordship, she appeared, your lordship, and gave statement, she developed a story that I had some relation with her while I was, the accused was a tenant of their house, your lordship, and then, your lordship, this POSCO and others have incorporated in that way, your lordship. Otherwise, your lordship, FIR is dated 13/7/2023. It says that I would like to state that on 11/7/2013 at 5:30 AM, my daughter, Miss Rosmi Begum, while on her way to attend computer classes, Sri Amit Das stopped her and molested her. While arguing with her accused, hit her with his mobile phone and on her forehead and slapped her. This was the allegation, your lordship. Now, when your lordship subsequently he gave her statement, your lordship, he developed the story that I had relations with her when I was a tenant of their village.
Who lost the FIR? The victim
FIR
herself?
was by mother of the victim, your lordship.
So FIR is not the encyclopedia
No,
of the.
definitely, your lordship, but there is no hint at all, your lordship. That's the problem, your lordship. Not a single hint, your lordship. But suddenly, your lordship, she said, your lordship, that when
Okay,
I
anyway,
was
let her evidence be recorded.
lost.
Heard Mr. Borthakur, learned counsel for the accused, and Mr. D. Sharma, learned additional PP for the state respondent. It is provided that the SSL call for up-to-date status report from the learned court below, fixing the matter on after 26 January
On 27 or 29.
29. 29.
Item 19.
Oblige.
Voter name application, my lord. The petitioner is the under trial prisoner, my lord. My lord, the allegation against the petitioners under section, my lord, the 342, 376, 323, 34, and section 4.
376B.
My lord, in this matter, during investigation, my lord, petitioners were not arrested, my lord. The trial court has passed an order on 22/6/2023, my lord, issuing available warrant of arrest, my lord. Then the police has executed the warrant. In terms of that warrant, my lord, the petitioners appeared before the honorable court, but the honorable court has taken them into custody, my lord, on 1st of September 2023, my lord. Since then, the petitioners were behind bar, my lord, already 131 days, my lord.
91 days.
131 days, my lord.
131 days.
Yes, sir. My lord,
So whether charge has been framed
Sergeant frame, my lord.
under section
Under section, my lord, 447 and 376B. And my lord, the 6 of POCSO.
whether notice was served upon respondent number 2.
Notice issued to my lord on our last occasion accordingly steps have been taken, my lord.
Pardon?
Last occasion notice was issued, my lord, accordingly steps have been taken, sir.
But not appeared.
No one appeared, my lord. My lord, may I draw attention to page number 25, my lord. The medical report, my lord. My lord, relevant portion is at page 26, last paragraph, my lord, remarks. Let's hear it is mentioned that no evidence of recent was found, my lord. And also stated, my lord, at chapter 4, my lord, next page, no injury marks found on her private parts, my lord. But allegation is gang rape, my lord. As such, my lord, the allegation is not believable, my lord. And in the other hand, the petitioners have no thus other involvement of any offenses earlier, my lord. My lord, as such, the petitioners will be enlarged on bail, my lord. Petitioner will be fully cooperate, my lord. Petitioners.
That's all right, but notice is yet to be served upon respondent number 2.
My lord, shorted.
No step has been taken by you
My lord,
as per office note dated 6/1/2024.
sorry, my, I have not, sorry, my lord, I have furnished, but they may not, my lord, furnish.
Take down office note dated 6/1/2024 indicates that no step for service of notice upon respondent number 2 has been taken by the learned counsel for the accused. Though by order dated 28/12/2023, direction was specifically issued for issuing notice to the respondent number 2. In view of above, it is provided that the learned counsel for the accused shall take step upon the respondent number 2 by registered post.
My lord, in POSCO case, I have to furnish to the office of the PP, my lord. PP will serve that notice through police officer, my lord.
Step be taken upon respondent number 2 through the registered post and also by usual process and also through the officer insert jurisdictional PS. List the matter on wet.
My lord, kindly give a short date, my lord, maybe on 19th, my lord.
19, whether you will be able to call service of notice.
I will take the steps today itself, my lord.
Okay. 19.
My lord. Obliged, my lord.
10, my lord. The petitioners are in custody for last 58 days, my lord.
58 days.
58 days, my lord. And 21B, my lord, less than commercial quantity, my lord. And the petitioner number 1 is the owner of a vehicle and petitioner number 2 was the driver of the vehicle. So on their way to
But this section 328 is also there. 328 IPC.
I don't know, my lord, why it has been used.
120B, 328 IPC, read with section 21B, 29 and
Main section is 21B, my lord. Less than commercial quantity of heroin has been recovered from the vehicle. And the petitioner number 1 is the owner of the vehicle and petitioner number 2 is the driver. On their way, my lord, one person stopped their vehicle and asked for a lift, my lord, by paying some rupees, my lord. So they allowed they took the person in their vehicle and thereafter, my lord, those articles have been recovered. And that person has been granted bail by the Session Court Nagaon around 2-3 days back, my lord.
Mr. Borba, you received the case diary?
My lord, case diary itself, Lordship.
Yes, is there any material against them?
My lord, regarding 328, Lordship, I have to go through again, Lordship, but this, my lord, contaminant is recovered from their possession, Lordship. Contaminant, this is my lord 247 grams of.
So today is 58 days.
58 days.
Here mandatory period of detention is
My lord, if the 328 is not there, then it will be 60 days, Lordship.
60 days.
And my lord, if your lordship perused the affair, there is no ingredient of 328, my lord.
Then why the case was registered under the said section?
That's why, my lord, because if your lordship perused the FIR, there is no
FIR is at page number?
page number 11, my lord. There is not a single ingredient line or ingredient of 328, my lord.
So 247 grams of heroin.
Yes, madam.
What is the commercial quantity? 250?
250 grams.
250 above.
Above 250.
Okay, heard, Mr.
BP product.
VP Bora, learned DP Bora, learned counsel for the accused, and also heard Mr. Arjay Barua, learned additional PP for the state respondent. This application under section 439 services referred by applicant, referred by two accused, namely Papu Das alias Sanjoy Das and Budhiman Tamang, who are languishing in jail hazard since 13/11/2023 in connection with Kanpur PS case number 170 of 2023 under section 120B 328 IPC, dated section 21B, public 29 of the NDPS Act. Is to be noted here that above noted case has been registered on the basis of an FIR lodged by one SI Ranjit Gogoi of Khatwal PS. So why the case was registered in Kanpur PS then?
Because it was under the vehicle and the persons were arrested under the jurisdiction of the Kanpur PS, my lord. Rangbang, my lord, in a place called Rangbang, my lord. That falls under the Kanpur police station jurisdiction.
No. The FIR was lodged by Ranjit Gogoi of Khatwal PS.
Yes, my lord, because they were taking that person, the other person who was provided lift by the accused person, my lord. From because from Pujai side, my lord, when they were coming, that particular.
Khatwal is under in which district? Khatwal PS.
Yes, my lord.
Where it is situated?
Nagaon. It is under Nagaon district only, my lord.
Nagaon.
Nagaon district, my lord. Khatwal. And the place, my lord, from where the petitioners have been arrested and the deceased have been.
That is under Kanpur PS.
That is under Kanpur PS, my lord.
On 13/11/2023, the essence of allegation made in the FIR dated so and so is that acting on a tip of the informant and other police staff apprehended one vehicle, Mahindra Bolero vehicle bearing registration number AS02AN 0787. Being parked in front of Ganesh Dhaba. And apprehended two persons, namely Bodhiman Tamang and Papu Das, and also recovered 247 grams of suspected heroin in soap boxes. Mr. Bora, learned counsel for the accused, submits that the accused were arrested on when they were arrested.
13/11/2023.
On 13/11/2023, and since then they are behind the bar for last
58 days.
last 58 days. Last 58 days. And that the quantum of contraband substance recovered from their possession is of intermediate quantity. And as such, the embargo under section 37 of the NDPS Act will not come into play. And that the accused are ready to go further with the investigating agency. And therefore, it is contented to allow the petition. On the other hand, Mr. Borua, learned additional PP, has produced the case before this court and submits that why the case is pending?
So it is to collect the FSL report, and also there are some other accused persons, they are not yet to be arrested.
So means that the case is pending for collection of FSL report and also for arrest of some other co-accused. Having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the case area with the assistance of Mr. Borua, learned additional PP. Indisputably, the quantum of contraband substance allegedly recovered from the possession of the accused persons are intermediate quantity, that is 247 grams. And they are languishing in jail hazard since 13/11/2023 for last 58 days. Further, it appears that the material part of investigation is almost over and the case is pending for collection of FSL report and for arrest of co-accused only. In view of above, this court is on the considered view that this is a fit case where the privilege of bail can be granted to the accused persons, and accordingly it is provided that on furnishing a bond of rupees 50,000 each with one surety of like amount to the satisfaction of the learned Session Judge Nagaon, learned special judge certificate NDPS Act Nagaon, the accused persons be enlarged on bail. Is there be returned?
Deeply obliged.
Item 21.
Legal also.
My lord, 69 days I am in custody, lordship.
Just now we have received the city lordship. I am going to lordship. Can it be after some at to lordship? Just now we have received the city lordship.
Do I have another matter fixed after some time? I have another matter fixed at 2 lordship.
Where?
In another court lordship.
Then okay, after 2:10, 3 o'clock,
Lordship.
in between 2 and 3.
Lordship.
Item 22.
May it please, O Lord, may the case various called for this case.
May receive the case. Then.
Case 12 is the FIR, my lord. There is some mistake in the translation, lordship, maybe I can actually select my.
So what is the allegation?
Hello, allegation is that, my lord, the informant, my lord, which was carrying, my lord, higher wood, my lord, that coil, my lord, it was made, that pan it is used, my lord, coil, my lord. That wood, my lord, it was being carried, and this present accused persons, they were in a Bolero vehicle, and they intercepted the vehicle of the informants, and my lord, they retained the vehicle along with the documents, and they stated that they are from the anti-corruption people. And anti-corruption people will come and they will do the needful. In the meantime, and there is also an allegation, my lord, that last line, my lord, that over phone, my lord, like this person accused, they left, and thereafter over phone, they threatened the, my lord, informant that if you don't give us 4 lakhs rupees, you'll be killed, my lord. That is over phone, my lord. So, my lord, 387 here, possibly no delivery of property, my lord, the extortion not complete, and that part, my lord, over phone that will kill you. That's why possibly 387 has been inserted. Now, my lord, what happened, my lord? Here, my lord, true facts is that, my lord, the petition number 1, my lord, accused number 1, my lord, he is a, my lord, honorary deputy advisor of the VDP, my lord, of Sirang district, my lord. We have annexed documents also, my lord. And the vehicle, my lord, which was, they were traveling, my lord, Bolero vehicle, that has been allotted by the motor transport office of the police department, my lord, because requisition from that, my lord, police department, that document also we have annexed, my lord. And my lord, VDP members there
And it is a fact, my lord, they had intercepted that vehicle because there was some allegation that, my lord, many, my lord, these illegal goods are being carried from Chirang district, my lord. And we have stated that we informed the SP also, my lord. And SP stated we informed the concerned deputy conservator of forest, Chirang. We informed them, they stated you be there. Then we were there, but this police personnel came from different place, my lord, they were arrested. And here, my lord, 387 is a non-bailable offence, my lord, and that possibly, my lord, that 41A, my lord, that has not been complied because 387, that is 7 years, my lord. And the forwarding report does not reflect that 41A was resorted to or why it was not resorted to. Allegation is there, my lord, that it is a fact, my lord, we have stopped it, but possibly bona fide, my lord. And regarding that demand, my lord, that is possibly, that is a false statement only to make out a case against us, my lord. And no police custody.
No, the question is who are you?
My lord, VDP secretary, my lord, chief secretary, my lord, chief honorary chief advisor, deputy advisor of VDP. VDP.
So
that is the number
where
one.
where do you get authority to check the vehicles
That
in
is
that
true,
way?
my lord. That is true. That is true, my lord. That is true, my lord.
Mm.
Because, my lord, they have possibly
So how long you are behind the bar?
for the last 22 days, my lord.
20?
22 days. Arrested on the spot 1812 and refused on 1912, my lord. And possibly, my lord, that document, my lord,
Yes, Mr. Borwa, what is the stage of investigation?
The stage of investigation also sufficiently progressed, Lordship, because the seizure has been made, witnesses have been examined, Lordship. Even, my lord, the TIP has also been done, Lordship.
TIP.
TIP, and also before the investigating officer also, they have admitted that, yes, we have stopped the vehicle, Lordship, and we have collected the documents, but we have informed the local police station, then the police came and arrested us, Lordship. And all the document it was seized from their, all the 6 persons position.
Okay, heard me, sir.
H.
Chaudhary, learned counsel for the accused, and also heard Mr. Arjay Borwa, learned additional counsel for the investigation. This application under section 439 says referred by 3 accused persons, namely Bapon Devnath alias Bapon Chandra Devnath, Niranjan Chandra Devnath alias Niranjan Devnath, and Shambhala Basumotari, who are languishing in Jailazut in connection with Bongaigaon PS case number 546 of 2023 under section 120B 419 387 34 IPC since 19/12/2023. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Harun Khan on 18/12/2023. The essence of allegation made in the FIR dated so and so is that on 18/12/2023 at about 4 p.m. the informant was carrying coir logs from Amgori of Sirang district towards Guwahati, and while he reached Saparkata, then 6 unknown persons, who arrived there in one Bolero vehicle bearing registration number AS01EZ6934 and in 2 motorcycle, wrongfully restrained him, being identified themselves as the person of anti-corruption branch, and snatched away the key of his vehicle from him, and also demanded a sum of rupees 4 lakhs from him. Mr. Chaudhary, learned counsel for the accused, submits that the accused have been arrested on 19/12/2023 for last 22 days, and that they are the members of Police Defense Party. And they also admittedly stopped the vehicle, but there was no demand as alleged in the FIR, and there was no delivery of money so as to attract section 387 IPC, and that they are ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. Mr. Chaudhary further submits that before causing arrest of the accused persons, no notice under section 41 and 41A of the Code of Criminal Procedure has been issued to the accused persons. Whereas Mr. R.J. Borua, learned additional PP, has produced the case study before this court and submits that though the IO has collected some materials in support of the allegation made in the FIR, yet the IO has achieved substantial progress in the investigation of this case. Having heard that line, it appears that the accused were arrested on 19/12/2023, and since then they are languishing in jail as well. Further, it appears from the case area that the IO has achieved substantial progress in the investigation of the case. Given the nature of accusation, the punishment prescribed for the same, and balancing the same with the period of detention, this court is of the view that further custodial detention of the accused persons seems to be not warranted in the interest of investigation, and therefore this court was inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned Chief Judicial Magistrate Bongaigaon, the accused be enlarged on by CWB later.
Much obliged.
Item 23,
23, we have not received the case diary.
It is for Azara Malad. Can it be on Friday, Malad? Other cases.
Mr.
That land.
Borua, learned additional PP, submits that he has not received the case diary and place for granting him some more time. Where is allowed, list the matter on when?
Well, not Friday, Lordship, definitely next week, Lordship.
Holidays.
Friday.
Kindly on Friday.
Friday, Lordship, several cases already filled.
Main case already granted cyber police Malad, that land grabbing case Malad, recently all arrested Malad. This is from Azara Malad. If possible on Friday, Malad, leave it to you.
How many cases? Oh, no, one. Okay.
Much obliged.
item number 24.
May please your lordship, for 39 application lordship, the NDPS X lordship under section lordship 21A or 29 lordship NDPS. Arrested on 25/12/2020.
Borua, case diary received?
Case diary not received, Lordship.
Lordship,
But this 21A is bailable offense.
21A is not bailable, Lordship.
Well,
Not
no,
bailable.
the.
1 year, 15 days lordship. Today.
Pardon?
21A is not bailable, Lordship.
No, in view of this schedule of SharePC, what is the punishment? 1 year.
Punishment is
1 year lordship. He's behind the bar lordship, the 1 year, 15 days today,
1 year?
15 days.
Hmm.
That is also which may extend to 1 year, Lordship.
Yes.
1 year, 15 days today.
So you were responsible for the same.
Tomorrow, Lordship, we'll try to produce the case diary tomorrow.
At 2 p.m. lordship. At 2 p.m. lordship.
Tomorrow to.
What is the punishment for 29?
29
Abatement lordship.
It is the abatement, Lordship.
Abatement?
1 year lordship.
1 year.
1 year lordship.
It means he is a consumer.
He is a consumer.
Consumer. Where is the FIR?
FIR page 8, Lordship. No recovery, Lordship, from me.
Pardon?
No recovery. In that,
No recovery.
no. 3.12 gram, Lordship. Other account, recovery from other account. Page 9, Lordship.
Hmm.
Recovery joint possession from the Piki Sunar, Sanjay Kumar Shah and the Dipankar Vyas. Ahmedabad.
Okay, heard Mr. N. Ahmed, learned counsel for the accused. And also heard Mr. Arjay Barua, learned additional PP for the state respondent. This application under section 439 chairperson is prepared by accused Ozit Boro, alias Garo, who is languishing in jail Hazard in connection with
25.
Bosisto PS case number 1035 of 2022 under section 21A of oblique 29 NDPS Act since 25/12/2022. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by SI Mukunda Sharma of Bosisto PS on 4/12/2022. The sense of allegation made in the FIR dated so and so is that acting on a tip of he along with other police staff have intercepted one vehicle. Have apprehended 3 accused persons at Kerakusi behind Hockey Stadium, namely Sri Vicky Sonar and Sri Sanjay Kumar Shah and Dipankar Bhuya. And after seeking and after conducting search of their person, they have recovered 3.12 grams of suspected heroin from their joint possession. The learned counsel for the accused submits that the accused was arrested on 25/12/2022 and since then he has been languishing in jail Hazard for more than 1 year. And that the quantity of contraband substance allegedly recovered from the joint possession of the accused person is below is a small quantity. And the punishment prescribed for the same is only 1 year. Only 1 year. And therefore it is contended to allow the petition. On the other hand, Mr. Borwa learned additional PP submits that he has not received the case diary and prays for granting him some more time to order the case diary. But in view of the nature of allegation and the period of detention, this court is of the considered opinion that without perusing the case diary, the bail petition may be disposed of. And accordingly, it is decided to dispose of the petition. It appears that the accused has been languishing in jail Hazard since 25/12/2022 for more than 1 year. Further, it appears that the case was registered under section 21A of like 29 NDPS Act for allegedly recovery of 3.12 grams of suspected heroin. Indisputably, the quantity of contraband substance allegedly recovered from the joint possession of the accused person is small quantity, and the punishment prescribed for the offense is only 1 year with fine. Para. Having regards to the nature of accusation and the punishment prescribed for the same, and balancing the same with the period of detention, this court is of the view that further custodial detention may not be required. Further custodial detention of the accused may not be required in the interest of investigation, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned Special Judge NDPS Act, Kamrup, Guwahati, the accused being allowed on bail.
His lordship, his fault lordship, he's entitled for default bail lordship otherwise.
He has not prayed
So
for.
1 year has gone lordship, right?
Uh, But you cannot say that because CD is not available with you.
That is why lordship, we like, Sarshid must have been maybe submitted lordship, that is also. Anyway, lordship.
Even Sarsit, even in the event of submission of Sarsit also, this 1 year only.
Item number 49.
Lordship, as per my instruction, in this case, charge sheet has been laid.
I don't submitted lordship.
Hmm. 22C.
You need to see lord.
Let the scan copy of the record and the case there come. Mr. RJ Borua, learned additional PP, submits that after completion of investigation, the case has been surseated by the investigating officer. In view of above, it is provided that registry shall call for the scan copy of the record of Dhuburi PS case number 345 of 2023 under section 22C NDPS Act, fixing the matter on when?
24.
24.
Item number 25.
25, we have not received the case diary lordship.
Since long it has been pending lordship, in a case for child marriage, lordship, mainly child marriage lordship, and POSCO has been added lordship. And where is the child age lordship? That she was born on lordship 7/3/2004 lordship. Since long it has been pending, lordship, pre-ARS bail lordship.
Pardon?
Pre-ARS bail lordship, since long it has been pending lordship for case in 1906 it was.
We will only take information lordship whether search is submitted in this case.
Pardon?
Whether search is submitted or not, we take instruction lordship. The CD not received today. Any more?
More than 6 months now. Whether notice was issued to the respondent?
No, at that point of time, lordship, that was not there.
41A.
No, the respondent of party.
Let's say POXO section 6 and 17 are there.
It came, lordship, later on, lordship,
Later,
all lordship.
even then, you have to take a step upon respondent to implead the respondent. Informant as respondent number 2.
Lordship, let him obtain the instruction, lordship, if charge is not filed, lordship, then we will implement, lordship, if lordship, says, lordship. Because we have to implement. the petition.
Mr. RJ Borua, learned additional PP, submits that he has not received the case diary and press for granting him some more time to take instruction from the concerned PS as to whether investigation of the case has been completed or not. Where is allowed, list the matter on when.
Well, I will fix it on my 22 lords.
24.
22.
22.
Much obliged, your lordship. Much obliged.
Item 26.
26 searches submitted.
Shiva. We are in interim, my lord. And IO might, my lord, not submitting the search sheet. Submitted. But the if my lord occasion failed to furnish.
Search it under section?
Well, under section 379, 411, 34.
When?
My lord, on 31/10/2023.
How long you were behind the bar?
No, the AB lord.
The CA is there, my lord.
AB lord.
AB, my lord.
Oh, this is AB.
My lord. We are on
Okay, you go and approach the trial court.
till done this order, my lord. Interim order shall.
Heard Mr. K. Bhuya, learned counsel for the accused on applicant.
5 petitions.
Applicants and also heard Mr. Arja Boro, learned additional PP for the state respondent. Apprehending arrest in connection with Lamding PS case number 158 of 2023 under section 379 411/34 IPC. This application under section 438 services preferred by 6 applicants, namely. Is to be noted here that above noted case has been registered on the basis of what FIR lodged by one. Lodged by SI Upendra Dev Sharma of Lamning PS on 5/8/2023. The essence of allegation made in the FIR dated so and so is that acting on a tip of he along with police staff proceeded to Haplongbar police station, Haplongbar railway station. Near Samasbari and found 26 bags of suspected Burmese supari and also found 4 persons who were working there as laborer for carrying the supari bags. And there namely Rajesh Kumar, Sunil Kumar, Sujit Kumar, and Rahul Rahul Kumar. And they disclosed before him that Ajoy Banik, Govindo, Joy, Master Ajoy and Sanjoy of Lanka and Manna Shah and Babu of Huzai are the owner of the aforesaid suspected Burmese suparis.
And lordship, no one lost the affair, whether the suspected supari was stolen.
Stolen or not. Mr. Bhuya, learned counsel for the appellate submits that the case under which the the sections under which the case has been registered are not attracted here in this case, as no one has lodged FIR against stealing of the seized Burmese suparis. And that the applicants are ready to cooperate with the investigating agency and therefore it is contented to allow the petition. Whereas Mr. RJ Borua, learned additional VP, submits that as per instruction. No, he has not received the case diary, but as per instruction, the IO has laid charge sheet after completion of investigation. Being charge sheet number
181/2023, dated 31/10/2023, under section 379, 411, 34 IPC.
Para. In view of the submission of learned advocates of both sides, this court is inclined to dispose of this anticipatory bail application by directing the applicants to appear before the learned court below and to apply for regular bail, and in the event
Lordship,
of
my lord.
filing.
It may be, my lord, interim order shall be continued, and after receiving a summon, then I will appear, my lord. This way, order may pass.
Uh, um, and to apply for regular bail, in the event of filing such an application, the learned court below shall consider the same in accordance with law within a period of 15 days from today.
And 29.
29. Till then, interim order dated 16/8/2023 stands extended.
28.
I'm on interim, Your Lordship. The FIR which has been lost in page 31, Your Lordship, dated 2/9/2023, has been registered against the petitioner who is owner of a vehicle which has been seized by the forest officer.
Where is the FIR?
Page 31. Page 31 is the FIR. The relevant portion is page 33. It is lost by one Macadola beat office, alleging that my vehicle has been transporting some sand cables illegally, Your Honor, on the forging some documents.
So you have been granted the privilege of pre-arrest bail.
Lordship, at that moment, since I was not present, now in hospital.
Have you appeared before the IO?
Yes, Lordship, I
My lord,
appeared.
When?
The appeared after receiving a copy of this order, Your Honor.
Acha. Okay.
My
Take down this page number 2. Order dated 12/9/2023.
My lord, here in hearing, my lord, we have received the case diary, my lord, and but it is not here. His statement is not available in the case diary, my lord.
Maybe the IO may not deem it necessary to record his statement also.
My lord, but as per order of this honorable court, my lord, after getting interim, he has appeared or not, it is not reflected from our case diary.
No, my vehicle has been seized, which has been released from the police
So
station.
he appeared before the IO.
Because of my releasing my vehicle.
As per their view, my lord, but here CD is up to 29.
Huh?
Up to 29, my lord, 29, my lord. But interim was granted, my lord, on
12/9.
12/9.
So whether you have appeared.
Because for releasing my vehicle truck, I have to appear before the IO for releasing of my vehicle. Since I have
No,
filed
for receiving the vehicle
I have-
and appearing before the IO
That
in
is
connection
different.
with the case is
No,
two
what happened
different things.
because after getting an order, Jima order.
My question is whether you appeared before the IO.
IO, that is, I have appeared, duly appeared before the IO, Lordship, and still gave.
Yes, so Borua, what is the
My
Mr.
lord.
Sama, what is the stage of investigation?
My lord, investigation going on, my lord. Some of the my lord, documents also seized by the my lord. Here, Bipul Ali's name is also here. He is the road permission, my lord. Transit pass, my lord. But as per allegation is that is fake also.
Transit pass was issued in the name of
A present petitioner also, my lord.
then?
But it was alleged to be fake, my lord.
Pardon?
Allegation is again, my lord. Allegation is that, my lord.
No, after
document-
issuing the transit pass, how can you allege that he have stolen the sand gravel?
No, my lord. That pass is itself, my lord, fake. Allegation is that, my lord. Lordship, but they are in interim manner, appeal city may be called after reopening.
No, why should we keep the matter pending for long months? In violation of the direction of Supreme Court.
I will,
This para number 1, 2, 3. Mr. Borua, learned counsel for the applicant submits that this court, by order dated 12/9/2023 was pleased to extend the privilege of period bail to the applicant. And pursuant to the said order, he had appeared before the IO and he has been cooperating with the investigating agency. And that the applicant is the registered owner of the truck bearing registration number AS25DC 8442, and the same has been released in his custody. And therefore, it is contended to make the interim order dated 12/9/2023 absolute in the same terms and conditions. On the other hand, Mr. Sharma
But
learned
one
additional
more
PP.
submission is there, man, they have not made party informant as the forest official, man. That is also reflected. Maybe,
Is it necessary?
my forest officer is the man here complaint informant, man, complaint.
That's all right, but without implementing him, interim relief has already been granted.
Right.
কি করলো লাইনটা?
On the other hand, Mr. Bishop, an addition.
And additional PP has produced the case before this court and submits that the transit pass which was allegedly issued in the transit pass produced by the applicant is a fake document. Is a fake document. And that the informant of the case has not been arraigned as a respondent in this petition, and that the investigating officer has collected materials against the accused and therefore applicant, and therefore it is contended to dismiss the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Sharma, learned additional PP. It appears that by order dated 12/9/2023, the applicant has been granted the privilege of interim period bail, and it is submitted that he had appeared before the IO and also cooperating with the investigating agency. So, okay, there is doubt in your mind that the Salan shown by the driver is a fake document issued by the allegedly issued by the Dhonpuri
Mild.
division. So it is your duty to confirm it from Dhonpuri division whether they have issued it or not. Hmm? Where is that confirmation? Where you have examined the persons of Dhonpuri division? Merely because you have suspected the Salan as a fake document is not sufficient to keep a person behind the bar. কি করলো লাইনটা?
It appears that by order dated 12/9/20, the applicant has been granted the privilege of intrinsically as bail and the person to the state order, he had appeared before the IO and also cooperating with the investigating agency.
Further, considering the materials collected so far in the case study, and also considering the submission of learned counsel for both the parties, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to make the interim order dated 12/9/2023 absolute in the same terms and condition. Case study be returned.
Mild.
Then.
Speaks twice, Lordship. They were absent on the last occasion. Only one point is involved regarding the sanction, Lordship.
But whether the other side is present?
Present, Lordship.
Acha. Yes. Item number 40.
Yes,
40.
yes, sir.
Yes, the point was whether
He was
at the time of filing of charge sheet,
yes, Lordship.
the appellant was
in
in
service.
service or not. That was the question.
Yes, Lordship. In the
Yes.
charge sheet is clearly reflected, Lordship. He was an ex-serviceman at the time of submission of the charge sheet, Lordship. And that fact, Lordship, in the judgment also, your Lordship may kindly come to page number 300, Lordship.
300 of
the
this
book.
paper book.
Paper book, yes, sir.
Yes.
300 of the paper book, Lordship, the down below paragraph 1, 2, 3, 4.
Uh,
4 para, Lordship. The warrant of prosecution saying, did your Lordship got it?
uh-huh.
1. The warrant of prosecution sanction was raised by the defense and it has been submitted on the point that at the time of filing of the charge sheet, the accused happens to be in his service for which the prosecution, as in the present case, without prosecution sanction is illegal. Accordingly, Lanet so-and-so counsel for the prosecution had the burden to prove that the accused was then not in service as a public servant, since the charge sheet, Exhibit 62, had been filed describing the accused therein as an ex-employee of the Ascot Bank. 2 days, Lanet counsel, the accused was then the supervisor as per the evidence adduced by the prosecution, while in the other of the charge framed against the accused, he was shown as ex-employee. Reliance was placed on the defense on so-and-so judgment when it is initially held that prosecution sanction for the retired public servant is also required under section 197 CRPC, but the counter ruling placed before me for the prosecution shows that the Honorable Supreme Court held in its case under the ruling where offense both under PC Act and IPC were involved, that no sanction under section 197 CRPC is necessary, and valid sanction for the offense under Act of so-and-so would suffice. It would appear that the present case was taken cognizance under the PC Act for the offense under section 13 thereof, together with the offense under PCA for which no prosecution sanction will be required. It's clear, Lordship, that the while submitting the charge sheet, the IO had filed the charge sheet under section 13 of the PCA. Therefore, sanction under section 197 is not required. And it's because he is an ex-serviceman, Lordship. Therefore, prosecution sanction is not required. Moreover, Lordship, it is clear in section 19 of the PCA Act, Lordship, if any question arises with regard to the validity of the sanction, that ought to have been raised at the early stage of the proceeding, Lordship. Here in this case, they are totally silent throughout the trial, Lordship. No question has been raised by the defense with regard to the sanction.
During trial.
During trial, throughout the trial, they are silent.
Mm.
Only during his examination under section 313,
Mm.
they denied that, they stated that he is in service, active service. However, Lordship, if your Lordship goes to section 103 of the Evidence Act, fact especially within the knowledge of the person, it is burden of proof lies to him, Lordship. He has not adduced any evidence to prove the fact that he is in service, Lordship. Therefore, Lordship, at that part, Lordship, I have placed one judgment L. Narayan Swami, it is of 2069 CC, Lordship, where it held, Lordship.
Yes.
Prior sanction for prosecution of public servant. Office held by the delinquent at the time of commission of alleged offence, and if he continues to hold that office, very office, when public prosecution is initiated, determined for the on the date of taking cognizance of alleged offence, office which accused held irrelevant for determining necessary of sanction. If on the date he ceased to hold the office which he had held as public servant at the time of commission of the offence, alleged offence, sanction not required to be obtained for his prosecution, even if he thereafter continued to be a public servant in a different capacity. If he holds a different office, Lordship, from the office he was holding during the commission of the offence, then also, Lordship, sanction is not required. This judgment will suffice, Lordship, regarding sanction, Lordship. And section 19 clearly had to be raised in the early stage of the proceeding, Lordship.
Yes, madam.
Lordship may kindly have a look into section 19, Lordship, PCA Act, Lordship, old Act, Lordship, before amendment, Lordship, prior to the amendment, Lordship. Prior to the amendment.
Okay, I will go through it.
Lordship.
Okay. Yes, what is
Yes, admittedly, I will not, I am not in the service, Lordship.
at that point of time? Acha, okay. Heard Mr. M. Haloy, learned counsel for the heard Miss Madam, your name?
B. Goswami.
B. Goswami, learned counsel for the appellant, and Mr. M. Haloy, learned standing learned special PP for the CBI. Argument concluded. Judgment reserved.
Lordship, may I place certain judgment with regard to certain fact, Lordship, with regard to the other fact, Lordship, I am placing some judgment, Lordship.
But the copy of the same be furnished to her also.
Copy of the judgment, Lordship. I'm sorry.
Timing item number 1. Timing item 1.
Lordship, 1. Along with Lordship, 32, Lordship, this is cyber PS case.
Yes.
CD is there, Lordship, in this one. 32 also same matter, Lordship. Item 32.
And where he has been granted bail? No, where the co-accused has been granted bail?
It was, Lordship, on 22/12/2023, Lordship. I have, Lordship, handed over the copy of the order.
So he's behind the bar for last 42 days?
Yes, Lordship.
Yes, so Mr. Borua,
My lord, otherwise, my lord, there is material against him also. Okay.
what is the stage of investigation?
Right. The investigation is pending because they might have other going to, they are yet to appear, Lordship. Because who has been granted bail and there are some accused persons, Lordship, they are not yet been arrested, Lordship. That is why investigation is pending, Lordship. They manipulate the volume book, Lordship, thereby they inserted my lord false salary, Lordship. And from the said volume book, they my lord produce the 35 copy of the new salary. And thereby, Lordship, they applied for mutation and then and thereby, Lordship, they Lordship do the wrongful gain. And they paid money to the my lord registrar, sub-registrar, everybody.
And who is this Pankaj Das?
He is the MP of the registration branch.
But yeah, I am only the home guard deputed at the office of the
You are home guard.
home guard.
Hmm.
In the office of the registrar of, I was deputed
Register of sub-register of
sub-registrar.
Acha.
And so far as the allegation of manipulation of documents and the data entry, data which were uploaded in the system, but I have no role to play because other persons are responsible.
Yes, so Mr. Borua. So what
Specifically,
materials are available against him?
My lord, he manipulated my lord this volume register also wherein my
Hey,
lord, yes,
how he is a home
he
guard?
along with other Lordship.
Pardon?
He is a party to the my lord gang Lordship. There are some
No,
persons
maybe,
in the-
but what role he played?
my lord, my lord inserted the name of the my lord person Lordship
Where?
in the my lord volume register Lordship, wherein my lord, while my lord in
Volume
other
register is a hard copy or soft copy?
was a hard copy Lordship.
Hard copy.
Hard copy.
How
These are
how
all
a
fake.
home guard can access to have
This
access
is-
to this?
This is the my lord conspiracy going. This is the conspiracy going.
Hmm?
And these are all done in lieu of money, Lordship. Use money taken by them, Lordship, and the co-accused has implicated him, Lordship. One Nitul Das, Lordship.
One?
Nitul Das, Lordship. He has
Who is
implicated-
Nitul Das?
Nitul Das, my lord, he is the my lord employee of the my lord, DC office, Lordship, and he works in the registration branch.
Hmm. Can I see the case data?
My lord.
You flag the relevant person. So apart from this statement of the accused, co-accused, is there any other statement of witnesses?
Witnesses, mother, he is one of the main accused also. He has implicated him because he is also one of the accused. Because he has not been named in the FIR.
Okay.
In this case, madam, nobody has been named named in the FIR. So investigation, madam, started, madam, arresting, madam, one accused, they after also on the basis of his statement, also. Other accused person arrested. The documents were seized also.
So Mr. Dotto, I will go to the case diary, pass the order.
Hello, regarding item number 32, lordship. This is also, madam.
Who is for 13?
32, lord.
32?
32. Now, in this case, this person was, he was granted interim protection, right, ordered at 13/12/2023, lordship. But I have not found his statement in the case diary, lordship.
Yes, whether you have appeared before the IO?
In the meantime, madam, he has been arrested in connection with a different case.
So he could not appear. Acha.
So we'll call for the up-to-date case diary, lordship. What is the report of the investigating officer, lordship?
What is the?
What is the report of the investigating officer?
So far, the petitioner is concerned, my lord.
Because the case diary is lying here for long time, lordship. Because there are several cases pending before this honorable court. No, arrest to Pusha is it?
So far, the petitioner is concerned, my lord, he is not employee of the, my lord, circle of this, my lord. He is the sub-register, my lord. Only because he came before this honorable court that police visited his place. That is why he was apprehending in connection with this case. But, my lord, the login ID of the circle officer, my lord, he could not get, my lord. He cannot get, my lord. He cannot misuse that login ID. He was not at all involved in this case.
Otherwise, lordship, there are.
Perhaps, my lord, police visited his place, my lord, in connection with the other case where he has been arrested. My lord, but he was, because when the incident took place, my lord, he was already working in Nagaon, not in Guwahati. He was transferred from Guwahati in the month of July 23, my lord, and the incident took place during October 2023, my lord.
But some allegations are there against him
There are several allegations.
regarding handing over of this TI book to advocates.
Yes.
May I pray, my lord, one thing I may be submit in this case, my lord. When this case was filed, my lord, before the honorable court, my lord, they have not, my lord, added the sections. There are, my lord, the 409 was added, and that was added 1 month before. And these petitions were filed after 1 month. But after suppressing the said material fact, they got interim order from this honorable. That is one aspect, my lord.
409.
409 added, my lord, 1 month before filing this application. But when they moved this application, that was suppressed by the petitioners and interim bail was granted.
By the petition.
And the interim bail was granted on that basis, my lord, because otherwise this case may not be listed before the, my lord, Honorable Justice, my lord, the M.K. Kalita, my lord, and it is to be listed before the Honorable Justice, my lord, as count, my lord. So, my lord, that was suppressed and interim order was, my lord, passed by the honorable court.
Certified copy was obtained, whatever was given, he applied, my lord.
My lord, because 1 month before, my lord, added, And these petitions was filed after 1 month, madam. How they can be, madam?
The certificate copy was provided after 1 month, the same certificate copy should have.
Okay, we'll see.
Well,
Okay.
Lordship
And after getting the interim order, my lord, he did not appear before the, my lord, IO, because he was arrested after some days, not immediately, my lord.
Lord, my wife is under treatment. She has done kidney transplant, my lord, in Kolkata. I was in Kolkata. I was about to come to, my lord, record my statement. But I was arrested in Kolkata itself, my lord. So, my lord, Lordship may call for the report of the IO, my lord,
Which report?
whether the petitioner is required in this case or not, my lord.
No, case diary is there.
My lord.
Why a report is necessary?
Well,
We'll
look,
consider his custodial interrogation is required or not on the basis of materials available in the case diary.
The instructions we have, my lord. Instructions we have from the IO, where it clearly says during investigation learned that that arrested accused so-and-so associated, namely Himanshu Das and other Kandan mafia gang strongly involved in occupying the vacant land by using muscle power and registering fake Lake Central fraudulently in a number at a various area of Kamrup Metro. And moreover, during investigations, it is found that the fake mutations of Ansar Ali case involved accused so-and-so, the late so-and-so, provide rupees 3 lakhs amount advocate Aniul Haq to make fake deed in the name of Ansar Ali and measuring two
No,
kotha.
is it a written instruction?
My lord, yes, it is a written instruction.
You filed a copy to the court master?
My lord, yes, yes.
Here also, my lord, the petitioner is not here. This is allegation is as regards the circular officer, not regard the petitioner. My lord. He is a sub-registrar.
Okay.
I'll provide him.
So your name is not there in the cause list?
I signed the Holatama, but I don't know why the.
Acha, okay. Okay.
And also, my lord, here we have found that Narendra Thausen and Ranjit Chaudhary demanded and took huge amount of money for registering a fake deed through commissioning and manipulating volumes of books, records, rooms from the various touts, brokers and advocates. Sub-register.
He has been arrested, man. In that case, he has been arrested already.
Okay, furnish a copy to the
My
court
lord.
master.
Lordship may kindly consider the case numbers, my lord. Whether
Definitely.
in this particular case, my lord, there is any allegation against the petitioner. Because there may be allegation in other case. In other case, he has already been arrested. And because of the arrest, my lord, he could not come to the my lord, IO for recording his statement.
Okay.
My lord. Okay, my lord.
Next.
Timing item 5.
Much obliged.
May I please your lordship? The FIR is in page number 8.
Page number?
8. This is a charge sheeted matter.
Associated matter. Under section?
The FIR was closed under 363, but in charge sheet one more section of it is 376. One number. They end the birth since 29 days. Type copy of the charge sheet is in page number 11. They were having a love relationship.
Okay, we'll call for the scan copy of the record. Where it is pending now?
What is
At what stage it is pending? Whether charge has been framed?
I'm not aware of.
Not sure. Okay. Registry shall call for the scan copy of the record of session case number 244 of 2023. Pending before the Court of Learned Session Judge Morigaon. arising out of Buragaon PS case number 10 of 2019. Fixing the matter on when
24.
24. RSSL also call for up-to-date status report from the learned court bill.
Obliged.
Timing item 14. For admission.
Paid your lordship. Lordship, this is a case for recalling the witnesses under section 311. On the last occasion, the learned PP was directed to inform us whether there is any inconsistency in the records. I think the records have also come, scan copies.
We have gone through the report, madam. And the eyewitness, there was people take statement we have gone through. There are some difference, my lord, in the statement. We have find some difference in the statement, my lord. And even my friend, he has also gone through the answer statement, my lord. But everywhere, all the eyewitness and PW we have gone through, my lord. They, according to 164 statement, my lord. Yeah. We have flag mark F, my lord. In the LCR, my lord.
In the LCR, your lordship will find the 164 statements as flag E and F.
Yes, my lord.
Yes.
Flag E is, your lordship will find the statement of one Sajida M. She's
She's the PW7, my lord.
yes,
She's the youngest daughter of the deceased, my lord. And also she's the eyewitness.
eyewitness.
So on what point do you want to cross-examine or re-cross-examine them?
Your lordship, in the evidence,
Where is the petition?
the petition is page 16. 16, para 4, the operative paragraph. Page 70, para 4. In the evidence, your lordship will find this informant has stated
Hmm.
that Neha Begum, she has instigated from the vehicle to kill the deceased. She
Hmm.
was stating ekebare maripela. So this particular point, your lordship will only find in the evidence. This particular thing was not there in the 164 statement also, and as well as the 161 statement before the police, and
Hmm.
also in the FIR. This particular thing your lordship will not find, that Neha Begum was instigating the others to kill the deceased.
Actually, in the first affair, my lord, the Neha Begum name was not mentioned, my lord. And
Also the statement, 161 statement.
but my lord, in one single statement, according to the eyewitness, my lord, they are not sure about the statement, my lord, but everybody says that Neha Begum was present in the vehicle, my lord, that inside the car.
Hmm.
But they said PW7, that is my lord eyewitness, and the younger daughter of the deceased, she said uh, uh, she have uttered the kati pela ekdom safa kori dibi, all these things, my lord. And then there is another eyewitness, my lord, that is Majiuddin, that is PW8, my lord.
Hmm.
They are from the same village, my lord. Even he said that he have seen Neha Begum sitting inside the car and instigating the accused person. That is the difference, my lord.
In the 161
What-
statement,
and
these
what-
things your lordship will not find, but
Yes.
subsequently in the 164 statement, they have stated that she was there in the car, and in the evidence, they have stated that this Neha Begum was sitting in the car and instigating the accused
Yes, my lord.
to kill the
And my lord,
deceased.
another eyewitness, that is PW6, my lord, is Azmol Ali. That is the grandson of the deceased, my lord. But he suddenly he has left, my lord, because when his grandfather was killed, my lord, he left. So there is no any statement from his side, my lord, because he's already left, and he's just 14 years, my lord. He's a grandson of the deceased, and he was present with him at the time of incident, my lord. He was the pillion rider, my lord, along with his grandfather. Another witness, my lord, 164 statement of this PW7 and 8 is important, my lord.
Otherwise, in regard to 164 statement, your lordship will only find in regard to Sajina Ahmad, Ajmal Ali, and Mujibuddin.
Mujibuddin, yes, my lord.
Rest of the witnesses, 164 statement is not there in the records.
So, how this impugn order
Yes.
dated 9/3/2021
Yes.
suffers from infirmity or illegality?
That's right.
Your lordship, here the learned court below has simply stated that there is no provision for calling for cross examination.
Hmm.
And saying that
The court below has held that there is no re-examination.
no re-examination.
And as such, there is no question for re-cross examination.
Yes, yes.
So what wrong with the learned court below?
But your lordship has the discretionary power to call for the witness if your lordship thinks it is necessary for proper adjudication and to meet the ends of justice.
Hmm.
Otherwise, it will prejudice me.
And,
So therefore, your lordship may exercise the power and may call these particular witnesses.
Hmm.
But lordship, it will delay the trial process, my lord, because already all the witness has been taken, my lord, already over, my lord. And he
Trial
want to-
completed.
Yes,
Trial PW.
Almost, my lord.
PW is completed.
and he want to re-examine 1, 2, 3, 6, 7, and 8, my lord. Almost all the witness, my
The
lord.
relevant witnesses. I
But
just
one,
want to examine.
according to me, my lord, one is not important because she is the elder daughter of the deceased and she was not present.
Hmm.
She is the informant.
Oh, informant. She is the informant, my lord, but she was not present.
And who, according to you, amongst these witnesses are important?
PW1, the informant.
She is the informant. my lord.
Then
PW1 is the informant.
informant, yes.
And then?
PW3, one of the eyewitnesses.
Uh,
Then PW6, grandson of the deceased.
Hmm.
He is also one of the eyewitness. Then PW7, another eyewitness.
hmm.
And lastly, PW8. These are the eyewitnesses.
He was present, my lord, at the time of incident.
No, merely because they are the eyewitnesses of the offense, you were not supposed to.
Your lordship, there is some variation.
Pardon?
Because there are some variation in the statements.
Maybe
and the evidence.
you have been given the chance to cross-examine them.
Yes, we have been given, but the thing is, that time, the old council was there.
They are newly
Subsequently,
engaged, ma'am.
yes,
That is the ground.
subsequently, a new council was engaged.
No, that is not the ground.
That may not be the ground, my lord,
So
because
therefore, I could not take, could
No,
not put
no,
the
that is
relevant
that
question.
is not the ground for allowing your petition.
Otherwise, your lordship, I'll be seriously prejudiced. So this limited prayer.
No, prejudice will be caused to the other side also, not to you. Okay, we will examine the matter. Heard Mr. S. Dotto, learned counsel for the petitioner, and Mr. D. Bora, learned counsel for the respondent number
2, my lord.
2, and Mr. R.J. Bora, learned additional PP for the respondent
My
number.
humble submission, Lordship, there is no infirmity of the in the order, Lordship.
Yes.
And they have sent advocate, Lordship. In earlier occasions, also they have sent advocate. Therefore, they have sent again new set of advocate. Now, this is the third advocate who has filed his application, Lordship.
No, no, as per my instruction, two advocates.
So, Lordship, may kindly pay the money in order, Lordship, page 18, Lordship.
Have you already gone through the last occasion?
That is why, Lordship, since they were not cross-examined properly, Lordship, they cannot file this application. After my lord prosecution examined the witnesses, after that they were allowed to cross-examine. After proceeding of the cross-examine, now they are filing this application to re-cross-examination, Lordship. Whether the re-cross-examination is permissible, Lordship. Lordship, kindly say the 397 of the CRPC, Lordship, division.
Yes.
My lord, the High Court or any session judge may call for and examine the record of any proceedings before any inferior criminal court situated within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and to the regularity of any proceedings of such inferior court, and may, when calling of such record, direct that the execution of any sentence or order be suspended if the accused is in confinement, that may be released on bail or on his own bond pending the examination of the record. Now, the subsection 2, Lordship, the power of the revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceedings.
Your lordship, this is the revisionary power, 397. We have filed.
Yeah,
under-
No, where do you get this third set of advocates?
Yes, my lord, that is, my lord.
Where it is
Lordship, may
mentioned.
kindly see the, my lord, the impure order, my lord, annexer P, page 18, Lordship.
Second.
Not third.
There are second council, my lord.
Second council, we had a second council.
Not third, my lord, but they are second council. And this incident took place in 2018, my lord.
Okay.
Long back, my lord, and still spending only, my lord.
Okay. Argument concluded, order is there.
Okay.
Obliged.
Deeply obliged, my lord.
Coming item 21.
Where will your lordship?
My lord, I am in custody since 69 days as on today.
60?
69. Since the accusation under section 376. Several sections are there. 379 is also there. Some other section.
Mr. Loskar, you have received the case ID?
Lordship, okay. Can you period the statement of the accused? Lordship? He himself admitted, Lordship, that he has made viral all those photographs in social media, Instagram, Lordship, and otherwise, Lordship, but Lordship, her 164 statement is not available with the CD, Lordship.
King statement is also there. Also, I have take market. King statement. I have take market. Also.
Statement of the victim guard,
Lordship, that is take market.
164,
164, that is not the CD Lordship.
recorded.
No, no, it is recorded, but Lordship, I have asked the IO to bring Lordship. He asked me to take some time, Lordship, to produce it, Lordship. It is recorded, Lordship. Therefore, this before the judicial ministry, Lordship. He himself impersonated himself, Lordship. He identified himself as another person, Lordship, and later on he, because of breaking the relationship, after coming to know that he is not that person what he has been introduced himself, he has done all these things, Lordship.
The allegations are there, whether true or false, I'm not on that, Lordship.
Hmm.
69 days in custody.
Hmm?
Whether further custody is necessary for the purpose of investigation. And further custody, whether the case. can-
Apart from that, we are to consider the nature and gravity of the
Yes,
offense
Lordship,
also.
that's true, that's true. With that,
Heard.
Lordship,
Heard,
my
Mr.
Lordship,
Your good name?
Am I?
M.I. Hussain, learned counsel for the accused
For a
and
moment,
also
Lordship.
heard.
Chief, my learned friend has submitted that 164 statement is not there.
Hmm.
And the IO also has sought for some time. May I pray that the CD be retained and the statement of the.
No, this material collected in the case diary are sufficient. Our 161 statement is there.
That photo. 69 days, Lordship.
At this point, there is no ground to disbelieve the statement under section 161.
If Lordship is that length of detention, may kindly.
The length of detention in each case, it will not come, Lordship. This is a offense against the society, Lordship. And he.
Victim is also
Okay,
major,
okay.
Lordship. Victim is also
Learned
major.
counsel for the accused and also heard Mr. P.S. Locker, learned additional PP for the state respondent. This application under section 439 services prepared by accused Siddiq Ali, who has been languishing in jail in connection with Cyber PS CID case number 4 of 2023 under section 376, 294, 419, 379, 201, 427, 506 IPC, read with section 66D, 67A IT Act. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by one Srimati X name withheld on 6/10/2023. The essence of allegation made in the affair dated so and so is that the accused impersonated himself as one Rahul Sharma and make friend with the informant and thereafter committed sexual intercourse with her against her will at Surat and also at Guwahati. And thereafter, no, and he also captured some obscene moment and thereafter make the same viral in the social media. The learned counsel for the accused submits that the accused was arrested on 3/11/2023. No, 2/11/2023, and since then he has been languishing in jail as of for last 69 days. And that further custodial interrogation detention may not be required in the interest of investigation, and therefore it is contended to allow the petition. On the other hand, Mr. P.S. Locker, learned additional PP, has produced the case jury before this court and submits that the IO has collected sufficient incriminating materials against the accused in support of the allegation made in the FIR, and therefore Mr. Locker opposed the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record and also perused the case they produced before this court by with the assistance of Mr. Locker, learned additional PP. Case indicates that the IO has collected sufficient incriminating materials in support of the allegation made in the affair. The offenses are serious in nature. Investigation is going on, and enlarging the accused on bail at this stage will hamper the investigation. And accordingly, the petition is dismissed. Case there will be returned.
Dismiss at this stage, lordship. Or dismiss at this stage, lordship.
Okay, at this stage.
Item 29.
Yes. Mr. Sharma, you received the case.
The case they receive, my lord. Case they receive, my lord.
Is there any material?
My lord, sufficient material is here, my lord. From the statement of the co-accused and other independent witnesses, my lord, they are involved in the selling of fake gold and some narcotic drugs also, my lord. And the present petitioner is also involved in the, my lord, fake currency, my lord. And some fake currency was recovered from him, my lord. And FSL report also received, my lord. From FSL report, it's clear that it is the fake Indian currency.
Yes, madam.
My lord, my case counsel is due to some difficulties from the matter and it taken up the people.
No, madam, the case there is available before the court. If we keep the matter pending, then the installation, no, then there will be no investigation of the case. So having filed the petition, you cannot keep the matter pending here for long period. When the CD was received?
My lord, earlier two occasions also they have, my lord, taken adjournment, my lord. In the 3123 order, my lord, written CD, my lord.
Hmm.
Yeah, but 3124 they have taken adjournment, my lord.
Hmm.
FSL report also proved that it was a fake currency on the FSL report.
So you submit, what is your submission?
Lord, I mentioned you morning mention.
Morning, we have declined your prayer. You argue the matter? Yes. What is your case?
Matter is offenses under section 120B, 420, 406, 489A, 489 under section IPC.
Hmm. What is the allegation against you?
If I'm like it. If I'm like it.
Yes.
Further, during interrogation, the apprehended person, Ismail Ali, stated that along with Tajuddin of does illegal act of transporting fake gold and fake Indian currency notes since long and supplying them to earn further money. According on the same day at about 9:30 p.m. as per input of Ismail Ali. The house premises of the Tajuddin of Sadargan was also searched in presence of the witnesses and following intense seizure from his house, but the accused Tajuddin found absconding from his house.
So what is your submission? Whether the allegations made in the FIR are correct or incorrect, or true or false? At about 10:15 a.m. today, a mention has been made by Ms. B. Das, learned counsel for the applicant, that her senior counsel is not present in the court and press for adjourning the matter to another date. The learned additional PP then submits that his AD has already been received by the received by her, and the same is being retained since 7/11/2023, and on 3 occasions adjournment was sought for and granted to the applicant, learned counsel for the applicant, and therefore it was opposed by the learned counsel, learned additional PP, to adjourn the matter to another date. Accordingly, it has been decided to hear the parties. Then at about 3 p.m. again, Ms. B. Das, learned counsel for the petitioner applicant, submits that her senior is not present in the court. Even then, the matter is heard. The learned counsel for the applicant submits that the applicant has been apprehending arrest in connection with Morazar PS case number 179 of 2023, registered under section 120B, 420, 406, 489A, 489C IPC. 489C IPC. And that the allegations are against one of the co-accused, namely Ismail Ali, who has implicated the present applicant with the offense alleged in the FIR, and that he is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP, submits that submits that the IO has collected sufficient incriminating materials in support of the allegation made in the FIR, and that fake Indian currency notes have been recovered from the house of the accused, the house of the applicant, and the FSL report has confirmed that the same were fake Indian currency note. And besides that, the accused are involved in another offense under NDPS Act, being Morazar PS case number 178 of 2023 under section 22C of NDPS Act. And therefore, Mr. Sharma has vehemently opposed the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case daily with the assistance of Mr. Sharma, learned additional PP. It appears that Morazar PS case number so-and-so has been registered on the basis of one FIR lodged by one Ankur Kakoti on 22/8/2023. The allegation against the present applicant is that acting on a tip-off, the informant, along with other police staff, has conducted search in the house of one Ismail Ali on 21/8/2023 and recovered one both shape golden colored metallic items, suspected to be fake gold with symbol cross embossed on it, surface weighing 1.7 kg, and he disclosed that he, along with one Tajuddin, are involved in transporting of fake gold and fake Indian currency note. And accordingly, a raid was conducted in the house of the accused applicant Tajuddin, and 6 numbers of 200 rupees denomination fake Indian currency notes were recovered from his house. And it also appears that from the house of Ismail Ali, suspected suspected psychotropic substances, that is 129 bottles of cough syrup, were recovered, and one case being Morazer PS case number 178 of 2023 under section 20 within bracket C of NDPS Act has been registered. In view of the materials collected so far in the case diary, this court is left unconvinced that custodial interrogation of the applicant is not required in the interest of investigation. His custodial interrogation is indispensable in view of the nature of accusation and the currency note recovered from his house. Therefore, this court is of the view that this is not a fit case where the privilege of previous bail can be granted to the applicant, and accordingly the petition stands dismissed. Case there will be returned.
Item 30.
Okay, case diary and medical report was positive.
My lord, here, my lord, POCSO 6 is here, my lord. Perhaps notice not issued.
You received the case diary?
Yes, there is, my lord.
Heard Mr. L. Mohan, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the respondent, state respondent. Mr. Sharma submits that the case was registered under section 376 3 IPC, read with section 6 of the POCSO Act, but no notice has been issued till date to the respondent number 2, the informant of the case. And accordingly, it is provided that a notice be issued to the respondent by registered post and also by usual process, and also through the officer in charge jurisdictional PS within 2 days from today, returnable on when?
After before lordship is the case diary is available.
When?
After view.
COVID.
Yes. On 22.
22. 22. Till then, case diary be retained.
My lord.
Item number 31.
This petitioner was granted interim lordship, right, order dated 28/11/2020. LCD was called to us.
LCD not received, my lord.
So you were on interim.
Yes.
Mr. B. Sharma, learned additional PP submits that he has not received the case aid. Accordingly, it is provided that Mr. Sharma shall produce the case aid for this court on when?
29.
From
29.
Till then, interim order dated 28/11/2023 shall continue.
34. 34.
No lordship for 38 application, CD was called for lordship.
My lord.
Sarsit submitted, my lord.
Sarsit number?
Sarsit number 352 of 23 dated 30/11/23.
Lordship, the Sarsit is against me or not? Sarsit submitted, Lordship. How many against is there? Sarsit is against me or not?
Yes, Sarma.
My lord, that information we will have to take, my lord. Tomorrow, my lord.
Tomorrow.
Right.
Mr. B.
Sarsit,
Sharma, learned additional PP, submits that he has not received the case they rebut as per his instruction. The IO has completed investigation and submitted Sarsit. But he is not sure as to against whom and under what provision the Sarsit has been submitted. And accordingly, price for granting him some time. Pair is accordingly allowed. Rest is at least the matter tomorrow.
11 Lorships. Today, tomorrow is, I am out of station.
Then,
11.
okay, 11.
Diplomats.
Item number 50.
Made please, Lordship, 438 bail application, Lordship, FIR case number 12, Lordship. The allegation made in FIR, Lordship, are false, Lordship. I am a local guy, Betel trader, Lordship, annexer 12, Lordship, annexer B, page number 13, Lordship. And page number 39.
My lord, here Sarsit submitted, my lord.
Lordship,
Hmm?
last date instruction was sought for, Lordship.
My lord, it is the last provision, perhaps it was 31/11, my lord. It was corrected, my lord, 30/11, my lord, 30/11.
Lordship, after perusal of records.
And under section?
Under 120B, 418, 420, 379, 411.
120B,
418, 420, 379, 411.
Sarsit number?
173 of 2023 dated 31/11. 30.
Lordship, I am on interim, Lordship. I have also recorded my statement, Lordship.
Interim.
Interim order first dated 28/11/2023.
Heard, Mr.
R. Islam, Lordship. On behalf of
Learned counsel for the applicant and also heard Mr. B. Sharma, learned additional people for the state respondent. Apprehending arrest in connection with
Parisera PS case.
Wazir Sarda PS case number 173
Lordship.
of 2023 under section 120B, 418, 420, 379, 411 IPC. This application under section 438 services prepared by applicant. Ziauddin alias Ziabuddin for grant of arrest bail. The above noted case has been registered on the basis of one FIR lodged by one SI Longsing. What is the name?
Longsing Pathan.
Crow. Longsing Crow. On 25/8/2023, the allegation, essence of allegation made in the FIR dated so and so is that acting on a tip-off, he has conducted search in the house premises of one Bulu Dorzi alias Fazlur Rahman. And recovered 179 gunny pigs containing Burmese supari stored in a room in his house, weighing 8,900 kg.
Lordship,
No,
may I submit
weighing
on-
8,920 kg. 20 kg. And during interrogation, Fazlur Rahman alias Bolu Dorzi disclosed that one Ziabuddin
My lord.
of his place is also involved in the offense. And Bolu Dorzi would not produce any valid document in respect of the aforesaid Burmese superis.
Lordship, may I submit one thing, Lordship? The alleged Burmese supari is not Burmese supari, Lordship. Annexure number B series, page number 13, Lordship. I have purchased all the local.
You argued that matter at the time of trial.
Lordship, subsequently, I have filed a Zimma petition for
Hmm.
release of local trades.
But his name is in the charge sheet, my lord. His name is here, my lord, in the charge sheet. my lord.
The learned counsel for the applicant submits that he has been granted the privilege of previous bail by this court by order dated
28/11.
28/11. And pursuant to the said order, he had appeared before the IO and he has been cooperating with the investigating agency, and therefore a contention is being made to make the interim order dated 28/11/23 absolute in the same terms and condition. The learned counsel for the applicant further submits that the superis recovered and seized by police in this case are not Burmese superis in view of the report dated
Number 13 in the name of Tasnia Enterprises, which was purchased in various dates by the petitioner.
in view of
Tasnia Enterprise.
in view of the receipt issued in the name of Tasnia Enterprise, where it is indicated that the superis were of local dry betel nut. Dry betel nut. On the other hand, Mr. B. Sharma, learned additional PP, submits that he has not received the case diary, but as per instruction, the IO has laid charge sheet, being charge sheet number 173 of 2023, dated 38/11/2023 under section 120B, 418, 420, 379, 411 IPC. In view of above, this court is inclined to dispose of this application by directing the applicant to appear before the learned court below within a honor before
29.
29, and to apply for regular bail. In the event of filing such an application, the learned court below shall consider the same in accordance with law. Till then, interim order dated 28/11/2023 stands extended.
Item number 51, 52, and item number 1 of production list.
One, two, three,
Production list. Lordship.
Yes.
Yes. The FIR. Page 41, 40 is where it starts, your lordships. May I just read 41 first? The FIR starts at page 40.
Yes.
Yes. Sale number 2. 120B, 406, 409, 419, 420, 467, 468, 471, 477, 8, 506, and 434. Next page is the list of the accused that are mentioned in the FIR. I'm sorry, just Lordship, I take it to the last paragraph of that FIR at page at column number 6. Complainant Amit Tipnis
Mm.
The next is page 41, Your Lordship, the name of the accused which are named in the FIR. Number one is Sachin Adhikari, in custody, is the husband. Tejaswari Sachin, I am before Your Lordship today, the petitioner. Mitali Sachin and Monishka Sachin Adhikari. They are the two daughters and the wife. 2, 3, and 4. The main accused is Sachin Adhikari, who is under the custody. He is obviously not well, he is in the hospital. Would Your Lordships now, because the 42, would Your Lordships now come to the complaint that has been registered, which is page 45, it's of 22nd of September.
Mm.
Page 46, Your Lordships. The allegation is that there are two companies that have been formed. One is Brit India, whose original company is in US, and there's another company called BWW, where both the complainant and the petitioners are supposed to be directors. Now, Brit was started in the year 1998 by the main accused, who is Mr. Sachin Adhikari, who has said to be the pioneer in starting the business, which is called an entrepreneurship for human development. They train people for which any companies that come to them, and they train in a entrepreneurship in a platform which is for common people where they can train. Now, these are happening by seminars in different parts of India. The business started in 1998 till 2011. The Mr. Sachin Adhikari was working for this company, which is Brit. Subsequent to this, he quit this company, and the complainant, Mr. Amit Tipnis, was brought into the company. So he came in 2012 as a whole-time director of the company. Same business continues from 2012. It continues till 2016, till Brit finally, the company, it was in US company, leaves India. Mr. Sachin Adhikari goes out of the company, and a new company is formed, which is BWW. The allegation is that the money has been siphoned off from this company and taken to certain shell companies, where shell companies are mentioned at page 50 of the FIR. And this money, one of the companies out of which, in which I am a director, which is Grey Matters, has also had involvement in the siphoning off. The siphoning is qua certain money which has been earned by Brit as well as BW, where both complainant as well as the petitioner are directors. The allegation is that I am a whole-time director controlling the affairs of the company. My husband, who's not before Your Lordships today, is the person who's controlling the entire affair and also been referred in BWD as the chief advisor. He's appearing the guy who's looking into the company affairs, controlling them externally. Now, the money that generates is that there is an amount of 139 crores, which is now being siphoned off from this and taken to the other companies, which are the shell companies. Now, 139 crores is a money which is being originated and gained from these two companies, which is Brit as well as BWP. They are businesses in which every aspect has been working by this gentleman called Mr. Tipnis. They are a 50% shareholders. Every transaction is audited. It's a money which generates from one company to the other company. Audited money, GST compliance is done, and the company is active till 2022. So the amount of money that they are talking about is 139 crores, generates from one company to the other. And then now the allegation is that's been siphoned off to a company which is Vista, which is owned by this gentleman called Mr. Sachin, who is accused number one, of which he's not a director, but a shareholder of 99%. So the allegation is, since he's my husband, I have every role in that company, and that the money was also been siphoned off with my being a part of it. Now, would Your Lordships come to page 47, para 2. The sole intention of the accused person was to use BWW, which is the company formed after Brit has left India in 2016, and was a tool for generating money to be siphoned off by them and leave nothing to the informant, the 50% shareholder of the company of BWW. So what he's aggrieved is the money that is generated from these two companies, in which he says he's entitled for a 50% shareholder. Therefore, he says, my share of money is also being siphoned off. The accused persons have several other shell bogus entities who were acting in concert with the pursuance of a common intention of who and forming a syndicate thereby defrauding the informant, siphoning off money partly via cross-border transactions, whereby the money amassed by the informant's honest labor was defalcated and siphoned off by the accused person, reducing the informant to the state of primary and loaded with a statutory debt. So the money that he talks about being siphoned off is money of which he has a 50% sharehold of a shareholder company. He is also entitled for that 139 crores, out of which 50% is apparently his money. And he being a director has signed all the transactions that has happened between 2012 till 2011, till the companies were formed and working. Would your lordships then come to para 5? Sorry, para 7, page 49 of the FIR. It's a slightly long FIR. I'm reading para 7, 4 lines from the top. However, it was made unequivocally clear that the informant that the status quo would be maintained and the accused person would resume responsibility and retain control of the said company and all its financial, operational, and management affairs in the capacity as a de facto directors and the final approving authorities. That Sachin Adhikari got himself appointed as a chief global advisor, which was the supreme post of BW, and all other posts were subordinate to him. Shashikant Tagade, who was the manager of so-and-so, towards 50% of the share, and accused persons nominated Nipun Raduna, who was initially a director of BWD Lordships, who then was substituted by another director. He also was before the Bombay High Court. He's also been granted, was a shareholder and was also now been granted a bail by the transit bail by the Bombay High Court. Subsequently, Advocate Rizwan Siddiqui, known as a reputed personality, was engaged to the other directors of the company along with the informant. So all throughout, whenever the business was going on from 2016 to 2012, the informant along with the other people were in full control in affairs of the company. They knew every transactions that was happening. Every transactions had their own signatures because these are financial, commercial transactions which had to be approved by all the directors of the company, in which the informant is also a 50% shareholder company. Obviously, there was a change of shareholder pattern because there was initially somebody else and then substituted by somebody else. Now, would your lordships come to para 50? These are the shell companies. The allegation is where the money has been shifted. Paragraph 9, I am concerned with number 6, grey matters. The allegation is there was a money of 90 lakhs which was forwarded by this company to the company of the husband, which is Vistar, where the allegation, para 9, 6. Number 6 is grey matters having registered offices so-and-so. The allegation has been countered at page 24. I'm sorry to take the lordships back to the application, page 24, where I have stated
Yes.
Yes. Lordship, that as the things were functioning smoothly, the entire country witnessed the COVID-19 pandemic and all the business across the spectrum took a hit. Even the business of Mr. Sachin Adhikari, now he's the husband, which was heavily manpower driven, took a nosedive and it was difficult to stay afloat of that times. It was at this juncture that the applicant advanced 90 lakhs through grey matters to Vistar to ensure that the salaries of the employer are paid in time and the company would stay afloat. It is also a matter of record that the sum of money also came back to trenches to grey matters. So the allegation that I was running, that the shell company has taken the money and the money has been siphoned off, 90 lakhs was given as a loan to my husband's company because during the COVID time, and that allegation now stands substantiated because money has also come back to us. Then your lordships, paragraph 51, page, I go back to the FIR. I'm sorry to go back on this FIR because the allegations are here. Page 51, para 10. With the ill intention of siphoning of the funds from BWW, a fabricated document was created by the accused person, fabricated document, whereby an agreement dated 16/3/2016, it is shown that BWD is a client of Global Vista. Now, I'll let you know, lordships, what happened. When this business was going on, when BWW was created, there were certain IT functions that this company was doing. The services was to be provided by this company called Vistar, where Sachin Adhikari, who's the husband, is supposed to be doing the IT back-end work, for which there were a lot of agreements executed. So the business was subsequently being handed over by BWD with Vistars. So it is not that the money has not gone out in a legal manner. The work that was supplied and given to us was also being handed over to them. They were giving us a client service and we were paying the money. Now, if your lordships remember, on the last date we had pointed out, there was a Section 8 insolvency notice that was issued. The money that was the business that originated between this agreement was ultimately a claim that was raised of 2 crores. So they went to the IBC proceedings. Money was not forwarded. We raised a counterclaim to say that an amount of 10 crores has to be given back to them. When that claim, they went and filed a Section 10 in the NCLT proceedings. The NCLT proceedings are still pending. It is only after that they come and file the FIR on 22nd of September and the complaint, and then the FIR on 23rd, trying to show that the commercial transactions between these two companies existed. I am saying that if any transactions have happened in regards to this was between the BWW along with a company which my husband was running. The allegation for me that I was a director and I have siphoned off company may not be correct, right? Because the only company that I was involved is Grey Matters. The amount that was transferred was 90 lakhs, out of which money has come back to me. Apart from that, there was nothing. This is an unsecured loan. Apart from that, to say that I am involved in the affairs of the company as a director, every role functioned from 2012, from where the complainant was abducted came into the company as a whole-time director till 2011. Every transaction that happened, both in BRIC as well as BWW, was signed and approved by the shareholder, 50% shareholder, Mr. Abhiktivnis, which was then put into whatever business they wanted to do. So it is not that I was not aware of what was happening. It was not that I have siphoned off knowing that he doesn't know the transaction. Each and every transaction, I'm sure the records will be available to show that it's a transaction. That is why even the Bombay High Court says prima facie it looks to be a commercial transaction. And it is a transaction which has happened. There cannot be two ways of it that the money has only gone for this purpose. It is a business transaction that has been happening since 2012. And he's been abducted, he's been incorporated in the company as a full-time director. Subsequently, companies are being floated. It is business that has been going on. And these are businesses for which GST is paid, income tax is paid. Every money has been accounted for. Today, to say that the money has been siphoned off is not correct. And if at all there is a share which the complainant is saying today, the share was because of his own doing. He was handling the affairs of the company, could not do it. He came for assistance. We've said in our application. It was only then that we refused by saying that this money is already available or has been used for business transactions. He then goes in and files this FIR. So money siphoning off is one part. Money gained by the companies is something that even the complainant is aware of. To say to him that this money has been siphoned off is not correct. It is gone on a business transaction. These are all commercial transactions that has happened. And secondly, most of the documents during that period are lying with the complainant. I don't have an access to all the documents, but the documents are available. These are documents which he is in control of because he is the person who is handling the affairs of the company. May I lordships and take to page 61 of the FIR, page 28, how Assam comes into play. Now, all the accused who are named, along with the complainant, the businesses named, all these companies which are mentioned in the FIR, in terms of the shell companies, are all registered in Mumbai. Now, how this place gets its jurisdiction, which I obviously have a separate cause of action, but I would like to read it out because it's mentioned in the FIR, is page 61, para 28. The money siphon activities have been done throughout India, including activities of BWD and the transactions pertaining thereto from Guwahati, and it is a substantial hub for their operations. At least since 2010, BWW has had 6 to 8 seminars as far in Guwahati. These seminars were held every year in Guwahati Medical College and Rajiv Gandhi Indoor Stadium. And the office that is been pointed out is a GST compliance office, where one gentleman called Mr. Pradeep Roy and Mr. Dilip Sharma was operating here. So the jurisdiction is that there are seminars held here. which has now become the bone of contention in Assam. Subsequently, this FIR is registered. On 10th, an STF goes, arrests me, brings me here, and I am then being arrested formally on 10th of December, shown as 10th of December. Picked up from Bombay on 9th, and then shown arrest on 10th. Now your lordship should see the Bombay High Court order. It's at page 63, annexure 2. I received summons.
We will decide the bail application, anticipatory bail application on the basis of materials placed before this court and also on the basis of material available in the case diary.
Yes, I am grateful.
So
I
not on the basis of the
understand, I
order
understand,
passed by
I
the
understand.
by High
But
Court.
the entire gamut is being shown as there is an involvement of 139 crores which is being defrauded and siphoned off. May not be exactly correct because that needs an adjudication. That's all I'm trying to say. That is not to that magnitude that has been projected before the court. 139 crores is a business deal. It's a business commercial transactions. That's what even the High Court has come. Would your lordship be kind enough to come to page 64? That's the Bombay High Court. It's a prima facie view taken by the court. And there is a reason why this view has been taken. Prima facie, it appears that the genesis of the alleged offense in the commercial transactions between the party, since accused number has been arrested and applicant in the genuine apprehension of an arrest, the applicant are women and are willing to appear before the investigator and cooperate with the investigation. It's a prima facie view. And in fact, one of the other directors who are shareholders, I'm sorry, Mr. Nipun Radu, also applied during the vacation. He's also got, and the similar view has also been taken by the High Court. And this is. Do you have a copy? This order was passed on 29th, your lordship, and similar view has been taken. Prima facie, it appears that the allegations are with respect of certain commercial transactions between the parties. I'm just passing on the order, your lordships. He was initially a director of a shareholder of BWW. Subsequently, he resigned, and Mr. Rizwan Siddiqui, who came into the company, right? May I just read para 9 of that order, your lordship, so permission. Prima facie, it appears that the allegations are in with respect to certain commercial transactions between the parties. Considering the pleadings and application and expressing the apprehension of an arrest, since this appears to be a genuine apprehension, the court is inclined to grant temporary interim protection to the applicant. And view of the order, then the order is passed. So the view is prima facie, it's a commercial transaction. As long as the commercial transaction is existing, you cannot say the money has been siphoned off at this stage. And I am not asking for acquittal. I'm not saying that please acquit me. I'm saying it's a bail application. I'm ready to participate. 2 occasions on 23rd. And on 4th, 3rd, 28th and 2nd of January, I was called by the investigating officer. I have appeared before the investigating officer, and I'm still ready to
When?
Yes, 28th and 2nd of January. 28th December and 2nd of January. Yeah. And I was called, I came here on 2nd, I was called on 3rd.
Your statement was recorded by the IO?
Yes, statement recorded. Both, there are two accused. All the three were before your lordships. All the 3 statements have been recorded. Monica, Mitali, Monisha, and Tejwashwini Sachin Adhikari. Their statements have been recorded.
Yes, Mr. Fukono, why the case has been lost in Guwahati?
My lord, here their office is there, my lord. It is in the FR also it is clear.
Because the registered offices of the companies are situated at Mumbai.
My lord, here we have seen, my lord, the FIR at page 29, my lord, para 29, 60, it clearly says, my lord, there is a register office is also there, my lord.
That's for GST compliance, yes.
At paragraph 29, my lord.
Acha.
It is there, my lord. That's why jurisdiction has come, my lord. Yes,
Yeah,
my lord. Para 5 was there,
why the
it is-
informant is Susan Guwahati for losing the FIR? Why not at Mumbai?
My lord, here the complainant, my lord, these 42 persons who were the address of the Guwahati, my lord, who run the business, they are also agreed, my lord, because this the informant, he is also, my lord, the investor of the said my lord, the business. Here your lordship may see the 48 para 5. Here also it's clearly say at the relevant point of time, due to the exit of the parent organizations Beat and Beat Worldwide LIC from India 2015, the accused person incorporated BWW Global, and by 2016, the whole undertaking, business, goodwill, trademark, and brand name, Beat was transferred to BWW Global by various agreement inter-se, and all the requisite permissions, license, and NOCs are obtained in this regard. At the relevant point of time, the accused person set up office at ward number 15, Bhaskar Nagar, Gotipa Swainson. It is there. That's why jurisdiction has come. And moreover, my lord, we have seen the case diary, my lord. There is sufficient materials, incriminating materials has been found against the accused petitioners. And moreover, the IO note is also there, my lord. After his appearance on first day, they have not cooperated, my lord, the investigating officer. And moreover, my lord, it is a, my lord, the huge financials, my lord, is siphon of the, my lord, money, my lord. So his custodial detention is necessary. And so far as concerned, my lord, the informant, his 164 statement is there, madam. And he clearly sees in his 164 that my name is Amit Tipani, so and so. Then accused persons, namely Sachin Adhikari, Tejosin Adhikari, there are 9 numbers of accused, my lord. And he said that, my lord, I lost the FIR because in the year of 2001, I joined the company of the accused person in the year of 2001, namely Breed WW India Private Limited, a company duly registered under the provisions of the Companies Act 1956. And I have seen number so and so with an assurance by the accused persons that as the business grows, I would be duly benefited. The head office of the said company, Breed WW India Private Limited, was located at the Bardham Chamber Plot 84, Sector 17, PS Basi, Navi Mumbai District, Thane, Maharashtra, in the year 2011. I was offered to take the directorship of the company when the accused number 1 resigned from the said company in the month of November 2011 to join another US-based company, Monavi. But both the accused number 1 and accused number 2, the present petitioner, my lord, Tejaswini Sachin Adhikari, retained their control over the company as shadow promoters thereof. In the year of 2014, the head office of the said company, Breed Worldwide India Private Limited, was transferred to Satra Plaza, second floor office so and so at Maharashtra. In the year 2015, the accused persons incorporated Breed WW India Private Limited due to the exit of the parent organization of Breed WW India Private Limited from India, and by 2016, the whole undertaking business and the goodwill, trademarks, and the brand name Breed WW India Private Limited was transferred to Breed WW Global Private Limited by various agreement, license, and NOC. At the junctures, an agreement was made that I would have 50% share of the profit generated by me. However, the accused person retained control of the said company and all its affairs in their capacity as de facto directors and financial approving authority. From 2007 till 2021, there are transferred of an amount of rupees 139 crore from Breed WW Global Private Limited to a number of a sales company and the firm of the accused number 1 and 2, present petitioners, where the beneficial owners are all the accused persons and the transactions are between the related parties and the persons under control of the accused persons. And I was unaware of the fraud as the auditor were appointed by accused number 1 in connivance with the accused number 2. On the other hand, accused number 2, 3, and 4, all the petitioners, the other 2 petitioners, Mithali and the Monisika, are the ultimate beneficiaries of the funds from the BWW Global Private Limited. It is their family business, my lord. They have opened 4-5 companies in their name, total 6 companies. And I
No,
had received,
merely because they are the beneficiaries of some of the amount being transferred to their use. Can it be said that they are also involved in the offense?
my lord, what happened the wife, Tejaswani, my lord.
No, wife is the director that of the
My lord,
company. That is a different
here
matter.
from
But
the-
against these two debtors,
my lord,
apart from
they say
being
that their daughter said
beneficiaries,
that,
what materials are against them?
my lord, yeah, their daughter said, my lord, they are studying and my lord abroad for taking my lord some study educations. But they have submitted bond, they did not do any work in India. They have no any job. But it is very difficult for her, my lord. If they submit that CS at that point of time, we are a beneficiary or my lord worker, it is difficult for her, my lord. Because they went, my lord, their visa will be cancelled, my lord, if that it be so. They go for education. And they did not say that, my lord, their visa was, my lord, allowed because of that they are not working in any other country. Or it is difficult for her, my lord, if they have stated at that point of time I'm working in this. And the entire, my lord, money, some money has been, my lord, transferred their account. Because it's a family connivance, my lord, the 120B is there. And moreover, you
yes,
lordship,
that's all right. 120B is there, but what role they have played in commission of these offenses
my lord,
by the
these
two
two daughters
daughters?
was used by their father and mothers, my
Hmm.
their mother and father, my lord, used, my lord, these two, her own daughters, my lord.
Hmm.
And moreover, my lord, these two persons, my lord, the Nipun Radhuto and the advocate Rizwan Siddiqui,
Hmm.
they say that, my lord, they are also, my lord, director and the, my lord, the shareholder and their signature is there, my lord. They have filed an affidavit, my lord. They say that no, the entire control is with the, my lord, Sachin Adhikari. He had, and when the 161 statement was taken, my lord, the Sachin Adhikari, he simply denied, my lord, I don't know, my lord, the Grey company. His own wife company, he said, I don't know, my lord, regarding, I am not aware of this company. And he said, my lord, I am the not owner of the Oceans company. They denied, but the other co-accused, my lord, they are the witnesses, they stated that no, he is the main director and he is the signatory authority and he signed all the documents and checks. It is there.
Hmm.
So, my lord, may I pray, my lord, the kindly see the affidavit. They say that the advocate Rizwan Siddiqui is the director. In his affidavit, my lord, he clearly says no. He is, my lord, only the. That is, my lord, filed by advocate Rizwan Alam Siddiqui.
Where it was filed?
This is an affidavit, my lord, in case diary we have found, my lord. There is notary affidavit, my lord.
Hmm. No, where and why it was filed?
My lord.
Where and why it was filed?
My lord, he explained, my lord, when the notice was issued to him, my lord, he sent a affidavit, my lord, file an affidavit and submitted before the IO, where your lordship may see the paragraph 19, my lord, of the affidavit. And he, my lord, explained everything, how he was appointed as a in the said company, my lord. It is there. Paragraph 19, he said, I absolutely shocked and surprised to receive and service legal proceeding of a notice and recovery from various bank NBFC governmental department which were addressed me to Mr. Amit Tipnis, being a director of the Messrs. BW Global privately informing us the company BW Global has failed to pay dues, loans and governmental dues. I stated thereafter my ICICI bank account was frozen. I stated I had no knowledge of the day-to-day business affair and function of the said company. I immediately confront Mr. Amit Tipnis, the informant. And here its submission is that, my lord, he is also, my lord, the 50% shareholder, their signature, but he did not aware of any transactions. So I stated upon the Mr. Amit Tipnis, I gained knowledge through Mr. Sachin Adhikari, his family members, and Mr. Sasikan Tajje and the other persons have misused the fund of the company and has forced the company to take a various loan from the banks and MBFCs under the use of the reviving the business of the company being so and so. that instead of reviving the business, these people being a control of the financial of the said company and had instead a transferred and siphon of all the loans amount and funds from BWW Global Private Limited and Vista International Private Limited and their other sale company, thereby making Messrs BW Global Private Limited almost bankrupt insolvent. Have not repaid the loan amount and was borrowed under the name of the company, Messrs BWW Global Private Limited, and having been failed and neglected to pay the interest amount on the loan, have not paid the relevant goods and service taxes, government and other statutory dues by company. Have till date siphon of the transferred fund of rupees 139 crores by BWW Global Private Limited and Vista International Private Limited through false and fabricated invoice, bills and booking false expenses, thereby prejudicing the right of the properties, goodwills and existence of Messrs BW Global directors and shareholders for their own personal benefit and for benefit of Messrs Vista International Private Limited, their other sale companies. I stated I have been messaged to Sachin Adhikari WhatsApp number so and so have informed him about the innumerable problem that I was facing despite not having a single decision in the company being so and so. And I stated I had asked Mr. Sachin to resolve the entire dispute concerning BWW and with the period of 1 week. However, despite calling upon Mrs. he has absolutely failed to neglect to take any step towards resolving the dispute. With prima facie make it evident that he had no intention to do the same and malified intention to ulterior motive to commit the offense of cheating, criminal breach of trust and dishonest misappropriation of funds, forgery, making false document, falsification of account, and consequently the convenience with the Mrs. Tejaswani Sachin Adhikari, Mitali Sachin Adhikari and Monisika Sachin Adhikari. Their name is there, madam. And other, my lord, we have found it is there, my lord, the bank statement is there. It is clearly shows, my lord, the how the money has been transaction one's accounts to other account. And the 161 of the main accused, my lord, Sachin Adhikari, when he was questioned by the IO, he said that I don't know about the Blue Oceans company. I have no still hear the name of the Blue Oceans company, but he is the proprietor of the Blue Ocean company and money was transferred to my lord, Blue Oceans company in many occasions. And I have know about the Genesis solution company. He is also the proprietor of the Genesis solution company. And again, he said, I don't know about the Gray Matters company. And Gray Matters company.
Where is the bank statement?
My lord, it is here, my lord, in the case then.
Acha.
It is there, my lord. I have flag marked, my lord. And moreover, my lord, we cannot read all the things, my lord, because there are already 9 accused. Others are still absconding. If I disclose everything I have here,
No,
my
not
lord,
necessary.
my lord, yes. And bank statement is here, my lord.
But my question is, apart from this statement in the FIR at page number, no, at paragraph number 15,
My lord.
what other materials are there to show the involvement of the daughters of the main accused?
My lord, here only we have found, my lord, the daughters said that they are, my lord, the studied somewhere, they have joined the company, they received salaries. That much is there, my lord. And regarding, my lord, the Mitali, I have not found so much, my lord, the materials against her.
But in Monisika,
Monisika, my lord, she said in her statement, then I work with Vista from 2011 as a product manager or development work in 2013. I went to London to study. I studied in the London School Economics up to 2014. In the meantime, I also part-time work with Vista International Private Limited. But at that point of time,
no,
my
that's
lord,
all right. But siphoning of the money from the
because money is, my lord, entered her account. It is there, my lord.
no, some amount of money may enter into her account, but does it mean that she has conspired with the main accused persons?
My lord, it is revealed, my lord, during investigation. Investigation is still going on, my lord. They may cooperate, but they are not
The
cooperating
thing
with
is
the
that
investigating officer, my lord. But
if
it is,
they have appeared before the IO,
my lord,
and they have been
Mitali is till date, Mitali is not appearing till date, my lord. They are showing that there are some COVID problems and they have some problem, my lord, suffering from, my lord, seasonal ailment. And regarding other 2 accused, first day they have appeared. Second day when they were called for, they say that we are sick, we are not appearing today. The police said that, okay, you appear some other day, but till date, my lord, they are not cooperating in the IO. In the case that he had clearly said, my lord, the IO, why his custodial detention is necessary. তদন্ত সহযোগ করা নাই। That's why it was there. And moreover, they have not disclosed the real things, my lord. That's why, because my lord, they use financials, my lord, scams. So, my lord, their custodial detention is necessary because they are not cooperating in the investigation. It is there in the IO note, my lord. And
Yes,
moreover, my lord, the lordship may ever earlier occasion also, my learned citizen also submit some citations regarding the economic offense. And I also submit some, my lord, the regarding economic offense, it should be treated as a class apart, my lord, not treated as a, my lord, general offense. It is, if your lordship may like to submit this judgment before your lordship, that is P. Chidambaram case. Para 83, my lord. How economic offense to be dealt with in the case of, my lord, anticipatory bail.
No, that case was concerning with the economy of the state. But here, whether it can be treated at par with that offense.
My lord, is correct, but here also, my lord, the money is, my lord, related to the, my lord, because, my lord, we have got the revenue, the exchequer has been gone, my lord, the government exchequer has been gone. It 139 crore has been siphoned without having, my lord, the government exchequers money. It also comes under the economic.
No, it was not the government money. It was the income of the company.
It is true, my lord, but because, my lord, the
How it affect the state exchequer?
My lord, that's why, my lord, if I go by the, my lord, the root of the investigation, then only you came to know, but it is, my lord, the just it is ground level, my lord. So that's why, my lord, the investigation is going on and their custodial detention is necessary. They have to cooperate with the investigating officer, my lord.
They have already appeared once before the IO.
But
The
next time, my
statements
lord,
have
he
been
was when he
recorded.
called for, my lord, further interview, because, my lord, the transaction is very much huge. That's why not a single sitting is enough for the investigating officer to, my lord, conclude the investigations. So thereafter, they have not cooperated with the investigating. It is in the case that I was clearly mentioned in the case that they are not cooperating.
Okay, you hand over the case.
May I just, may I just?
Okay, yes, Mr. Sodari.
My lord, my only submission would be, going by the nature of the allegation, perhaps, my lord, custodial interrogation would be required in this case. It's a complex matter, my lord. It's not a very plain and simple. 2-3 things are now quite clear. That the mother and both the daughters are beneficiaries of some illegal action. Now, of course, at this stage, things have not crystallized, but they're definitely beneficiaries, my lord. And from the other day, I have showed, my lord, how 95 lakh was deposited from Vistar, my lord. And Vistar is being managed by the husband. And most importantly, my lord, in the FIR, certain documents were annexed, which are not before lordships, which document would reveal that Sachin Adhikari till date, though he left the company in 2011, he is still managing the show, my.
No, those documents are available with you.
Yes, my lord, in the FIR. In the complete FIR, they have not annexed.
So you furnish those documents to the
Yes,
court.
my lord. I got it. Page 64 onwards. And you see, everywhere his signature appears. The complete FIR I'm handing over, my. My humble submission is, my lord, after going to the CD, Lordship will take a call on the issue. IFSC, there are materials. 64 onwards, my lord, where in every document the signature of Sachin Adhikari appears, who is controlling the affairs.
We are not concerning with Sachin Adhikari right now. We are concerned with the wife and the daughters, 2 daughters.
The wife, she is definitely.
That's all right. She is one of the directors.
Yes.
But against the 2 daughters?
Leave it to Lordship. Regarding the daughters.
Yes, Mr.
Regarding the
Fukan.
daughters, Lordship will take a call.
after going to this.
I'll just clarify. One or two things has not fallen in the right perspective. On 28th of December, all the three appeared. One of the girl goes back, suffers from COVID. On 3rd, 2 comes back. So 1 couldn't appear. So 28, 3 appears. On 3rd, 2 appears, 1 couldn't come. So we have said she will come back. I think she's on a process of being recovered. She's been detected with COVID. I have the document, number 1. The entire gamut of the argument is Sachin Adhikari. I agree. It is Sachin Adhikari. Vistar has nothing to do with me. Vistar is correctly 99% shareholders of Sachin Adhikari. My client, along with the 2 daughters, have nothing to do with it. That is why they are not able to answer your lordship's query. They are not directors. The 2 daughters went to London to study. They are studying social entrepreneurship, comes back and decides to help the father, takes a salary in the NDFIR. Is that an allegation for saying that I have defrauded a money which has been siphoned off from a separate company, has no entity on this? On an anticipatory bail to say, this is exactly what I'm saying, it's a commercial transaction, needs to be decided. I'm not running away anyway. The lordship can put me in task. I'll come. I'm ready to come, and I have come because I'm innocent. Whatever money has flown in regards to Vistar is relating to my husband. I do not deny it. I have no authority to deny it. I am saying it's a transaction that has happened between the Amit Tipnis, the complainant, which has got 2 companies along with Vistar. I have nothing to do with that. That's my case. I stand on my own foot. I don't need that. I have gone to London, studied, come back, and I've taken salary. It's written in the paper. Everything will be in record. Number 1. Number 2, they say Rizwan Siddiqui was a director till 2020. I have submitted a small document. As I said to your lordship in the beginning, some documents I do not have as of now. I have no control. But till 2020, it is an audited document to show that he was a director. Today, to give a statement and say I was not a director is wrong, because this is what it says. I have passed on the document to prove till 2020. This is the document I had, and I've submitted to you in all fairness. I am not saying that he's a director now, that I'm saying he was a director of the company after Nipun Raudi. So that allegation remains. He was there. Today, to come and file an affidavit and say that I'm not concerned with the company, or that that my petitioner has taken away the money, on what basis? That needs to be investigated. I'm still saying that I'm ready to cooperate. But a transaction that I'm not a part of it. This company, that every time the word uses Vistar, agreed. Sachin Adhikari, agreed. Call him, investigate him. He's been here with you for last 20 days. Have you recorded the statement? No. No statements have been recorded. I have been called now, after the bail applications have been filed, 41 notices have come to the other accused. Till now, nobody has come. Why? You only want to target me. You are arm twisting now the wife and the children. I agree. They were a part of it. I'm not saying they're not a part of it, not of Vistar. I stand and I repeatedly stay on my own feet. I have a company. I have said that. I have not denied anything. I'm ready to participate. If there's a documentary that repeatedly has been said public money. What public money? It's between 2 different companies. It's a private transaction. It's a commercial transaction. Let the IO investigate. I have no problems. Not a single money has been taken from the bank. Nothing.
No, there is allegation that this Tipnis has taken a loan from the banks.
Yes. So that's
Then is it not public money?
So then he's also responsible. That's what I'm trying to tell your lordships. He's a 50% shareholder of that company.
But he has
That
taken
money
the loan and you have transferred the amount to your account, cell account. No, cell companies.
That's not my company. Vistar is not my company. It's my husband's company. I admit. It's my husband's company. 99% shareholder is owned by him. I'm not denying it. I can't deny it.
But you are one of the director of the company.
No, not for Vistar. I'm for BWW.
No, maybe, but the other 2 companies.
BWW.
Yes.
Yes, that is the wife. The wife is the director of BWW.
Yes, I'm telling about you, the wife.
I said BWW. Oh, even in BWW losses, I'm sorry, I stand corrected. She's not a director in BWW also. She's not a director in BWW.
But
There are two
there
directors
is
in
specific
BWW.
allegation in the FIR itself.
Rizwan Siddiqui and Amit Tipnis. That's the information we have till 2020. The document that I submitted.
Yes. Okay.
So that document, that information is available in the ROC.
Okay. We are not reserving the order. We will upload it in due course. But till then, Mr. Fukan, yesterday's instruction. Till passing of the order, no coercive action. It is not written, but it is verbal.
Not,
Huh.
I'm only requesting you.
Keep yours.
Record that at least from my hand.
So, Mr. Fukan, you submit the.
My lord.
Orders, item 37.
I'm extremely grateful.
None appears for the. Yes, you are for item number 37?
Your lordship.
Yes.
And this IA for bail pending appeal of the case, my lord. In this case, matter, your lordship kindly pass FIR, my lord. সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱাকালি ইংৰাজী ৩
So, you have been sentenced to suffer imprisonment for
7 years, my lord.
7 years.
One thing, my lord, in this case, my lord, I have two grounds, my lord. Actually, the girl is there.
No, whether the record has been received from the court below.
Received, record.
Received. Then we will finally hear the matter.
After today, my lord.
Not today. Time is over now. After Bihu vacation, we will finally hear the matter. Record received.
Received.
Mr. Sodhuri, have you gone through the record?
My lord, one thing is the IA is pending, my lord.
No, that's all right. We will dispose of together with the appeal. This IA and the appeal together. As agreed by learned advocates of both the parties, Registrar shall list the matter on COVID.
On 31,
No, sorted.
the 23rd or 25th?
23rd.
23rd.
23rd. Okay, 23rd. On that day, endeavor will be met to hear the appeal and the IA together and to dispose of the same.
And on that day, if my lord, if the matter is not hard, my lord, then bail petition may be considered, my lord. If time.
No, we will hear. We
Yeah,
will hear.
okay.
মোচনটো থাকক সেইটো মানে কথা বাকী পিটিশ্যন কি হ'ব বৰটা লাভ Okay.
38.
Lordship, I want to make a prediction. Lordship.
Yes.
In this matter, I was furnished with the relevant documents.
Yes.
But some of the documents were not furnished, Lordship, and of the depositions, only one of the pages backside was not submitted.
Not submitted.
Item number 37, Lordship. I am preparing for the informal, Lordship.
Okay.
Incomplete.
You take down, Mr. Sodhuri, learned amicus curiae.
Legal aid, Lordship.
Legal aid counsel for the respondent.
Respondent number 2.
Respondent number 2 submits that though some of the deposition of some of the witnesses have been furnished to him, the same are incomplete, and therefore he submits that he may be provided with the complete deposition of all the prosecution witnesses. Pair is accordingly allowed. Resti shall furnish complete deposition of all the prosecution witnesses to Mr. Sodhuri well ahead of the date of hearing.
Obliged.
38.
Yeah, please, Lordship. My lord, as per office note, my lord, it was for service report, my lord. But neither ID card nor usual service report, my lord, returned back, my lord. My lord, this is a long pending case, my lord. But this matter may be listed before Lauzima court, my lord. My lord, with the direction to the registry to check the postal track report, my lord. My lord, long pending case, my lord. Before Lauzima court, with the direction to
check the postal track report.
You can also check the postal, postal tracking report.
My lord, I can also, my lord.
Yes, you can obtain it and furnish to the court.
Yes, my lord, I will produce before this court. My lord.
Yes.
Next date may be fixed, my lord.
Office note dated 7/9/2023 indicates that service report in respect of respondent number 2 has not yet been received. The learned counsel for the petitioner submits that he may be granted some time soon to produce the postal track report before this court. Pair is accordingly allowed. List the matter on when?
24th,
After what?
After 1 week. Okay,
on 24th,
24. 24.
Okay.
39.
Wait, please, your lordship. My lord, in this matter, my lord, actually, my lord, it is an appeal, my lord, which was fixed for hearing, my lord, on the last 3 or 4 occasions, my lord. But today, inadvertently, my lord, it came up for orders, my lord. My lord, the issue is that, my lord, the appellant was convicted for 3 years, my lord. And he has already been behind bars for 2 years, 6 months, my lord. So, my lord, if your lordship gives me, my lord, only 15 minutes, my lord, I can conclude the hearing, my lord.
This
The
matter?
urgency is there, my lord.
What urgency?
My lord, only 6 months left, my lord, and there are absolutely no material, my lord, for conviction, my lord. So, my lord, if your lordship does not want to hear the matter today, my lord, then my lord, matter may come up tomorrow or my lord before Bihu vacation, my lord.
Kobe, how many matters listed tomorrow? Eh? আদি হল মঙ্গলবার বুধবার বৃহস্পতিবার একদম। So immediately after reopening of
I
the,
will take only 15 minutes, my lord.
Pardon?
Small matter, my lord.
pardon?
I will take only 15 minutes, my lord. Small issue involved.
You see, where is the time?
No, not today, my lord. Before Bihu vacation, 11 or 12, my lord.
No, lot of matters fixed before vacation. So again, the matter will not reach. Kobe, can it be on 18? 18?
My lord.
18? Okay, as agreed by learned advocates of both the parties, list the matter on 11 at 2 p.m.
My lord. I will.
For hearing 41.
My lord, it's a coercing matter, my lord. Times and again, it is listed, my lord, it is part hard also, but it will take some time, my lord. So, my lord,
When? 18th? As agreed by learned advocates of both sides, registrants shall list the matter on 18th at 2 p.m.
my lord.
2 p.m.
42.
Your lordship, state is the appellant here, your lordship.
Pardon?
State is the appellant here, your lordship.
Acha,
My lord, this is appeal against equity, lordship.
yes,
The long old pending matter of 2009, lordship.
yes.
Last that your lordship, they stated to submit a written argument, your lordship. Last.
Written argument.
Yes, your lordship.
Written argument is not necessary, lordship. Make my lord dispose of the matter, lordship. My lord, not today, lordship.
On 18 then? 18. As agreed by learned advocates of both sides, registrants shall list the matter on 18th.
18 and 19.
19.
19.
On 23rd or 25th, lordship. Too many questions. Hearing matter. Tuesday or Thursday. And Tuesday is 23rd. Thursday 23rd or 25th.
Tuesday, 23rd. Okay, at 2 p.m. PM.
Item 43.
Oblige.
My lordship.
Hmm.
A hearing matter, lordship, 2012 appeal. Today there may not be time.
You are on a 43 or 44?
Lordship, I am on both of them.
Are they related matter?
No, lordship, they are not related. In item number 43, I am for the appellant, lordship. In item number 44, I am for respond number 2.
Acha,
Separate matter.
separate matter. So suggested date then?
On 30.
On 30, lordship.
30?
Lordship.
Okay. As agreed by learned advocates of both sides, arrested shall raise the matter on 30.
44.
That please, your lordship. My lord, sir, kindly the matter may be fixed on 25th, my lord, because he is in jail, my lord, and case of agriculture.
25th.
Yes, my lord.
Okay.
20 at 2 PM, kindly.
As spread for by Mr. Odin, learned counsel for the appellant, arrested shall raise the matter on 25th
25th at 2 PM,
at
kindly.
2 PM. Okay.
May I, lordship? Lordship, I may not be available on 25th. Can it be on 30 at 2 PM, lordship?
Acha.
I have to go for medical checkup of my dad, lordship.
Okay.
30.
32 PM.
30.
Okay.
2 PM, lordship.
I'm blessed.
Deeply obliged, lordship.
45.
May I please, your lordship?
45, yeah.
Yes, Mr. Rosset.
Sorry, he's come wrong side. I'm the petitioner, immediate petitioner, Milord, against 125 proceeding. So, Milord, time is not there. So, Milord, any other date, Milord?
When?
1st February.
Huh?
1st February.
Proceeding is.
Shorted to 125 matter.
It will be on 23rd, Milord, your lordship, 23rd January.
23rd.
23rd January, Milord.
Okay, we'll try.
Or 24th.
As agreed by learned advocates on both sides, arrested shall raise the matter on 23rd.
24th, 23rd is
23rd is Tuesday.
Tuesday, huh?
20?
Okay, yes.
20?
23rd, yes.
23rd, okay.